Your Lordship, permit me.
Mention inclusion of containers.
Mention on Mondays.
Yes, with regard to the matter that was heard yesterday,
Yes.
we forgot to point out that the sale notice was in respect of 6 companies. So, my lord, I was just wondering that if it could be restricted, my lord, to OTB, who was the petitioner before. I've given notice to Mr. Vachawat. I don't know. Where's the notice?
Mr. Yes.
I don't think Mr. Bordhan can have a objection to that. And fairly, I think he says that. So the sale notice, I can.
That was regarding different properties of different.
It was a combined sale notice, for about 5-6 accounts.
So only the petitioner's account, as far as it will be restricted only to the petitioner's account.
Only petitioner, my lord. So your lordship has, I think, stayed the sale notice.
Yes.
If your lordship permit.
Yes, that I recollect.
And this up, my lord, I'm sorry, it's marked.
It appellate side to chilo.
Original
side.
Original side. Oh, I'm so sorry. But my lord, the sale is in the morning, my lord. That's
yes. Please just hand over the order.
The order is not here.
Order is not
yet.
Yes.
Oh, uploaded. I'm so sorry.
Supposed to be uploaded yesterday because we stayed back for a long.
I think Mr. Prusti didn't even comprehend that it would be uploaded yesterday.
So what can be done? No origin side officer is there also. Even
if I shall come back at 3 o'clock. But
no, not 3 o'clock. Please come back at 2 o'clock because today 2:30 division bench with justice.
I'll come back at 2 o'clock, my lord, and but in the meantime, my lord,
can you ask any of your learned? Even a clerk will do just to inform the origin side officers so that they come at 2.
I will do that. That I will do.
So do that, please. I'll take up at a supplementary list bar করে দুটো সময় এই ম্যাটারটা to be mentioned রাখতে হবে। হ্যাঁ বলে দাও। It will be at 2.
I'm so grateful.
But your auction starts before that.
My lord,
I was apprehending the bench yesterday. That's why day before I was mentioning it.
My lord, your lordship will permit us to go ahead with the auction, my lord, and this, my lord, we've drawn it to your lordship's attention, but due to logistic
no
problems.
difficulty on that. Tomorrow, if something happens to me, then you will be in difficulty. There may be every eventuality should be
improbabilities, my lord. We have to.
Yes, but Mr. Shah, we can never be sure of anything.
My lord, I'll my lord, inform my officers, my lord, they'll take a call on that, my lord, with your lordship's kind grace, my lord.
It will be only a one-line order. Madhav, আপনি একটা order নিয়ে ওদের communicate করে দিতে পারবেন? It's not possible. He won't be able to upload that also. That's the difficult. If you can bring any of the officers, origin side officers, তুমি একটু ফোন কাউকে দিয়ে করিয়ে দাও। Immediately চলে আসো। ট্রেনে আসছে।
Gods are conspiring against. My lord, I'll try to, if kindly grant me the permission, my lord, in case I can get hold of any of them, my lord,
please do
I'll bring them, my lord.
I'll pass a formal order, one-line order, just I'll modify this or do something. I'll restrict it only to the petitioner's account.
I'm grateful.
Thank you.
Deeply.
Let this be with me.
Yes.
Yes.
So,
my lord, item number 48 of today's list.
Yes.
This is tender
one
matter.
of the items. Yes.
This is tender matter. On Monday, I mentioned this. My lord, because
no application, call on the list.
Lordship, I'm praying for
no further mention.
Lordship, I'm praying for leave, your lordship. Lordship,
number 1.
Leave, your lordship.
Refuse, Ms. Ghosh.
Lordship, kindly hears me, lordship. I've been served with a notice, your lordship.
No.
Lordship, lordship, kindly hears me, your lordship. I'll be praying for a leave to file to move the matter on Monday, your lordship. I've been served with a notice wherein my certificate is cancelled and it has to be returned within 7 days. Lordship, kindly consider.
No, Ms. Ghosh, no. I said no. Call on the list, yes.
Grateful, your lordship.
Who is appearing in item number 1?
Lordship, I am for the petitionaries along with the writ petition. I have submitted the deposit, Lordship, to the Undersecretary as per your Lordship's earlier direction.
It's clear.
On 12th of July.
What was this?
Lordship, this was relating to those
Return of
passports which could
passport.
not be traced, Lordship. They were seized in 2017.
All right.
And then my instructions are, Lordship, from the regional passport office that they had
Petition, you're for the petition?
I am for the petitioner, Lordship.
Lordship
Lordship,
passed an order
petition is-
directing the Undersecretary.
Undersecretary
But,
What is this?
This
Special messenger cost.
special messenger cost, Lordship.
It was a rule that was to be.
That was, a rule was issued upon the respondent number. Lordship, this matter relates to.
Oh,
the-
they were directed to appear or
Lordship-
something? No,
No, not yet. Lordship, if,
No, no, no.
you were representing them also.
No, no.
Lordship,
no.
not
not
yet. Lordship, I'm appearing for the Union of India. Ultimately, I suppose I shall.
Lordship,
But the passports have not been traced out. Actually, from the passports were sent to the at Delhi to the Undersecretary. That was the RTI
Lordship was
communication.
pleased to direct us to serve notice. Accordingly, we had served it and intimate the date. Thereafter, they didn't turn up. So your Lordship was pleased to issue a rule upon them and direct the petitioner to submit the special messenger cost on 12th of July. Accordingly, we have
Office করে
submitted.
এটা report দিয়েছে।
Whether it has been served or.
এটা তো office report। In the order dated July 11, 2023, it was observed that the matter concerns the issue of seizure of the passport of the petitioner on the ground of illegal immigration, and that the apparent insinuation was that the petitioner is a Bangladeshi national, to establish which nothing had been produced on behalf of the respondents as of that date. Who's the next para? Learned Counsel for the Government of India had submitted that the passport had been forwarded to the Undersecretary where it was lying then. Full in such view of the matter, the Undersecretary was directed to be impleaded and to be served with a notice by the petitioner. Full next para. More importantly, it was recorded in the order dated July 11, 2023, that since the Undersecretary chooses to remain unrepresented despite service of notice by the petitioner, the court directs the Undersecretary to ensure that he/she is represented on the next returnable date when the matter is called on for hearing. Next para. A rule was also issued for the purpose through the office via special messenger, for which special messenger apostrophes costs were also directed to be deposited by the petitioner by the next date, a receipt regarding which is produced in court and be kept on record. The court also recorded that in the event such special messenger's cost was put in, a rule would duly be issued to the added respondent indicating that the matter would appear today at 10:30. The matter is appearing at 10:30 when the petitioner and the Union of India are represented through counsel. A report placed by the office dated July 27, 2023 indicates that the rule was duly served and was received by the concerned office of the Undersecretary, Government of India, MEA, CPV Division, Patiala House, India Gate, New Delhi, pin 11,01,000, and the same was received by the concerned office on July 24, 2023, as it appeared from the report of the section officer, Central Dispatch Section. It is seen that even today when the matter is called on for hearing, the Undersecretary is not represented through counsel. In view of such nonchalant attitude of the Undersecretary, the matter is fixed for hearing on August 8, 2023, when it will be listed fairly when it will be placed fairly at the top of the list. It is made clear that in view of the deliberate abstinence of the undersecretary to be represented in the matter, comma, despite repeated service of notice and rule, comma, it will be deemed that adverse inference can now be drawn against the office of the undersecretary on the merits of the matter. Full stop. Accordingly, let the matter be placed on August 8, 2023, fairly at the top of the list for passing final orders.
Lordship.
This is not a contempt, so I'll not direct the undersecretary to appear because I did not pass any direction on the undersecretary. I cannot compel somebody to be represented. At best, we can draw an adverse inference and
then-
pass an order against the
Yes, Lordship.
undersecretary's
From
office.
2021, the petitioner is languishing in this manner. From
Unimportant
2017.
cases, they don't need to. Very good. Yes, call on the next one.
Item 2, 1030 matter.
My lord, I have instruction to appear for Union of India. No copy has been served in my
No copy has
office,
been
although
served.
FIDs has been challenged. And I just now ascertained from my private secretary, in the late evening, email of a voluminous document has been served in the office when the office was closed. And your lordship is aware when the constitutional validity is challenged under the Civil Procedure Code and the Appellate Side rules, under Order 27 Rule Capital A, Attorney General must be served before adjudication of any matter in the dispute.
My lord, I believe the Attorney
And
General has
second-
been served.
Yes, he started in the evening and he shall remain in the office to receive the state government's notice.
Mr. Chakravarti, let us not get excited unnecessarily.
No,
Why
second,
your health will deteriorate?
Second, lordship has no determination to take up the matter.
Why that?
Yes,
Now it is my turn to.
yes.
Yes.
This is a NIA matter
Yes.
and this is moved a malafide petition after the division bench directed on a contested hearing
Hmm.
that NIA should investigate the Ram Navami violence. That matter
Ram
was
Navami?
violence. That
This
took
is pertaining to the Ram Navami violence.
Yes. And secondly, this was challenged before the Apex Court.
Yes.
Apex Court has Monday has affirmed the order of the division bench, and thereafter this petition has been taken out.
No, why do I don't not have jurisdiction, Mr.
Yes,
Chakravarti?
because NIA
Yes.
falls within the other agency under list 1, 7th schedule, NT2 capital A. This is police, and that is their case. I have
Oh, it
done-
should go before the other bench. That's
Yes.
right.
And
Yes.
secondly, my lord, this is another malafide attitude. My lord, Mr. Manta, as his lordship was taking up the determination,
Yes.
there was a petition moved by the NIA for transferring all documents to the NIA for taking the investigation. That has been completely suppressed in this petition. And this matter is fixed before my lord, Mrs. Joy Sengupta as item number 3 today.
This matter.
Yes, no, the order which is required to be passed again on the state of West
Anyway,
Bengal.
Mr. Mukherjee, if I don't have jurisdiction, I'll not take up the matter.
No, no, your
NIA
lordship
is
has,
also police.
your lordship has jurisdiction, my lord. Kindly look at my lord.
No, Justice Sengupta has police.
No, no, kind.
I'm appealing for the NIA, my lord.
Well, let him add then, Mr. Mukherjee. Yes.
My lord, I am conscious stating with responsibility, my lord. But I have gone through the live streaming link yesterday of the YouTube link.
Of what?
I have seen, my lord, when the leave was being sought for, my lord.
In this matter?
Yes, my lord. My lord, I will be, my lord, humbly beseeching your lord.
How do I look on the internet?
It's available on YouTube. my lord.
How do I look on the internet?
Nice, nice.
Since you are following the live streaming, so I should have a feedback on that. Start with that so that I release the matter.
Oh. my-
Oh, yes. Yes, Mr. Bhattacharya, I'm sorry. Please continue.
But I will be humbly beseeching your lordship, my lord, for
Determination.
revoking, my lord, the leave granted. Because leave has been granted under Rule 26, my lord, it has been dispensed with. Now, what was not spelled out before your lordship yesterday, when
Yes.
leave was sought for, was, my lord, that investigation into these violence was directed by the Honorable High Court at Calcutta in a.
This is regarding the Ram Navami violence of our state. Yes,
I'll tell it to your lordship, my lord, one by one.
right?
First of all, my lord, in a public interest litigation, there was a mandatory direction for transfer of.
Mr. Bhattacharya, if I don't have determination, if I release on that ground, I won't go into this.
My lord,
And if I have determination, I'll definitely take up that.
because the state has approached the court of equity. my lord, with
How can I revoke the leave without these being recorded and decided on?
Remember, my lord, kindly recall, my lord, what.
Mr. Bhattacharya, even if a leave is granted, even if a matter comes before on my list, even without a leave, it can come. If it comes, if I don't adjudicate, definitely the leave need not be revoked. I'll record your submission that the leave should be revoked, but I don't find any necessity for that. Where is the question of leave being revoked? Where is the chance of that? The leave has been acted upon and the matter is appearing today.
The fact, my lord, that the matter being disposed of 48 hours prior to the leave being sought for before the Honorable Supreme Court of India, that was not indicated.
That was not within the know of the court. How could it?
No, that was not indicated by the
Anyway.
court. And thirdly, my lord, this is nothing, my lord, but a counterblast. The NIA has filed a writ application where order was passed.
Mr. Bhattacharya, I'll definitely not go into these issues. If I take up the matter, I have to go into all these issues. Otherwise, I won't.
So far as the other point is concerned, my lord,
Determination, that is the most important part.
Central agency, my lord,
That is the crucial issue here.
a cursory glance at the petition, my lord, the grounds will reveal, my lord, that they are saying that their contention is that it is a police matter.
Very well.
Adjudication is vis-a-vis or where the police.
Yes, Mr. Mukherjee, then if it's a police inaction matter, another bench has determination. Since an objection is taken, I'll record that.
My lord, kindly have a look, my lord, at the determination, my lord. 14. My lord, of my lord, courtroom number 14. My lord, that's entirely, my lord, for your lordship's, my
No,
lord.
Mr. Mukherjee, because this was interpreted by a subsequent, another circular was there by the then Chief Justice. Those
Oh,
are
that's, my lord.
suitable.
My lord, kindly have a look at this, my lord, 14, my lord, once. Court, my lord, I believe, my lord, that's page 361, my lord, of, my lord, the cause list, my lord. Or, my lord, page 375 of today's list.
I'm sorry. Yes, 375. Justice Shenmugh.
My lord, it says, under article relating to police under residuary group 9, including applications connected thereto. Now,
No,
my
Mr.
lord,
Mukherjee, there was a previous circular regarding
I
this.
have it for your lordship.
Please do that, please.
First is,
And
my
give a
lord,
copy to
the-
Mr. Mukherjee also.
First is the notification dated 31/8/2022, where, my lord, the determination was spelled out. Now thereafter, there was a further clarification.
You are for the NIA and Mr. Chakraborty, you are for the Union of India. Yes.
Thereafter, my lord, there was a further clarification on the 30th of September 2022.
Please find out the page for me, Mr. Bhattacharya, on this.
I-
The relevant-
I
it is
copied
the-
to Mr. Mukherjee.
No, yeah. On my side.
Right?
Yes, this is the notification.
oh, I'm sorry, my lord, your lordship. We'll share, my lord.
No, it's all right. Let him find out the page for me.
Yes, I'll find it out for your lordship. My lord. My lord will kindly take pen to my lord.
This is a central agency. NIA is a central agency. Definitely.
My lord, the last entry, my lord, in this page, and if my lord kindly turns overleaf. The, my lord, the determination which at that point of time, the Honorable Justice Moshubi Bhattacharya was having.
Anyway,
is now-
Mr. Mukherjee, let us not go into waste time on this. I'll release the matter. I'll quote this.
Kindly see the date of this, my lord, 31st August,
No, 30th September 2022, this circular,
2022, my lord.
this has not yet been revoked.
No,
It
no,
was,
thereafter, there is another. But I'm there was a similar question which was raised.
Mr. Chakraborty appears for ED.
Yes, there was a similar question. He has handed me over with a copy
Yes,
of a clarification, my lord.
yes.
এখানে করতে চাইছে না ওরা ওখানে
এরকম দেখিনি মানে একটা মানে
Have you seen the outcome of that clarification? See the entire thing.
No, that matter, my lord, which was heard by your lordship, my lord.
So you're sure that outcome won't visit this matter?
But that I understand was being extensively heard. I had a word with Mr. Chakraborty.
Yes, it was.
It was extensively argued.
It was.
Extensively heard.
It
but
was.
then this clarification came.
Very
My lord, it is, my lord, it cannot be disputed, my lord, that.
Yes, Mr. Mukherjee, let us not, if there is a dispute regarding determination, why should it take up?
No, my lord, I.
Unnecessary and
No,
apprehension of
my
bias.
lord, I appreciate what's fallen from your lordship.
Yes,
My lord. My lord, your lordship, my lord, because my lord, these are monthly determinations which are determined. My
Right.
lord, here, my lord, we have to go, my lord, by the cause list. My lord, of my lord, July 2023. Now, my lord, if you're, my lord, my lord.
So there could have been a bona fide, mistake on,
No, my lord, my lord, if your lordship feels your lordship doesn't have determination, that's fine.
no, let me release.
Then, my lord, I'm not going to, my lord.
No, don't need. Learned, additional solicitor, yeah, Mr. Chakraborty, I'm sorry, you're the additional solicitor general. Learned, and Mr. What is Mr. Bhattacharya?
Deputy Solicitor.
Deputy solicitor general, I'm sorry.
In the other matters,
No, these designations I regularly, only the Advocate General is easy to remember, so I remember Mr. Mukherjee's designation.
There is the additional Solicitor General. We were previously known as the Assistant Solicitor General.
Don't tell me that I'll forget in the course of this. Let me pass my order, then say those things. Learned Additional Solicitor General appearing for the Union of India, as well as learned Deputy Solicitor General, appearing for the NIA, submit that the matter does not pertain to the determination conferred on this court by the Honorable the Chief Justice. Full stop. It is submitted extensively by placing reliance on two notifications of the court that the determination for taking up matters pertaining to police inaction, as well as which includes matters pertaining to the CBI and central agencies, has been given to a different bench. First up, learned Deputy Solicitor General places reliance on a partial modification stroke clarification to the appellate side and original side roster stroke determination notified video notification number 4224-RG dated August 31, 2020, effective on and from October 31, 2022, that matters relating to CBI and central agencies in writ petitions under Article 226 of the Constitution of India are already included within the comprehensive reading of subject category within single inverted police, single inverted clause in the appellate side rules, therefore, there is no need to mention CBI and central agencies separately. Full stop. Next para. On such premise, the said expression stood deleted. Full stop. There is nothing on record to indicate that there has been any subsequent revocation of the said notification. Full stop. Accordingly, this court does not have determination to take up the matter. Full stop. That apart, it is required to be noted that since elaborate arguments have been extended at the outset pertaining to the determination of this court to take up the matter, the judicial propriety demands that the matter be released by this court, having determination or otherwise, since if the matter is not released, a perception of bias may be lent to subsequent hearing before this court regarding this matter. Full stop. Accordingly, I choose to release the matter on the ground of lack of determination. Let the matter now with liberty to the parties to mention for inclusion before the appropriate bench, having determination to take up police inaction matters, including CBI and central agency matters. Learned Deputy Solicitor General reminds the court while parting with the matter that the learned Deputy Solicitor General has also taken a point that the leave granted by this court for inclusion in the list, on the prayer of the petitioner, be also revoked. Full stop. Next para. However, I do not deem it fit to enter into the grounds of such prayer, since an adjudication of the same, either way, might pertain to the merits of the case, which, in view of release of the matter due to lack of determination, I am not inclined to enter into. Thank you. Next matter.
But a hard copy should ideally be supplied by the state to the central government and the NIA.
Hard copy of?
The pleading.
no, this has to be served to the London Attorney General in terms
Hard copy of the
mandatory
leave.
rule.
Hard copy of the
We've served, my lord.
That is not the latest stream.
Lordship's rules under Rule 26.
Particularly for Mr. Chakraborty, no hard copy.
No, I cannot receive any matter where
I know that.
constitutional validity is challenged. It has to be served.
My lord, we served the Attorney General.
Yes, we have an.
Why not, soft copy?
Soft copy, your Lordship's court has not amended the rule as yet. The soft copy can be served.
No,
on
there
the-
is no rule. It has to be a hard copy. A copy has to be served. That is the rule.
But I
Not
received-
voluminous document of more than 600 pages.
That is easier to
If
serve
it is
online.
If it is served in
Chakot,
an
you have
office,
to educate yourself on this
it is
online thing.
served in an office when it is closed, whether it is possible
It's
human.
much easier to serve it by email because it's voluminous. We are saving the trees also, Mr. Chakot.
This was-
Yes, next matter.
Now that the matter is over, my lord,
Saying there's a
I'm
clarification.
sure, my lord,
that
I was very desirous of arguing the case to your lordship, because I'm
CBI
sure, my lord, I would have succeeded on the point of, my lord, the
Verification,
petition has been
feature, that's what they
directly
produced. That
I have to save my energy now.
So this is for future matters or this matter? Are you being sincere? If it is for future matters, Mr. Bhattacharya, no need of this.
immediately gets.
No need, absolutely. Yes.
We have to
Thank
you. Have said.
Do we mention item number 3 for release?
My lord, I am for the petition.
Yes, yes.
My lord, and the writ petition filed on 2022 and December. And the earlier court,
Why are you asking for release?
my lord, the pendency of the suit in the city court. The dispute only 10 minutes, my lord, the
For early hearing?
early hearing. My lord.
Learned counsel for the petitioner submits that the petitioner requires the matter to be heard urgently, full stop, since this court did not allow upgradation in view of pendency of other urgent matters in the list, comma, learned counsel seeks the matter to be released for being assigned before some other bench. Full stop, accordingly, WPA 29160 of 2022
Okay.
is released in view of the prayer of the petitioner with liberty to the petitioner to seek assignment before an appropriate bench, before a different coordinate bench.
Okay.
Thank you. Next one.
Item 4,
Yes, Mr. Banerjee.
Well, this is that matter where
Yes.
Lordship had reserved for orders, and I had said yesterday, my lord mentioned it. I've given notice to them.
Oh, acha, right.
My lord, paragraph 42 spells out of my lord that these matters are not being taken up by the NCLT and all. But yesterday the matter was taken up. They have, my lord, appeared there. They have sought for an order. They have also said that the recalling application be listed in the list. Therefore, my lord, why, my lord, the writ jurisdiction would be, my lord, also, my lord, entertained just because, my lord, both the jurisdiction they're trying out. And this is the cause list of yesterday, my lord, of the NCLT. I've just marked it with my pen. Well, both the jurisdiction, there cannot be a forum shopping. Paragraph 42, page 23. my lord.
দিয়ে রেখেছি সেটা দেয়নি কপি এটার একটা অর্ডার ডিকটেশন দিয়ে রেখেছি পল্লব সেটা দেয়নি সে না মিস্টার ব্যানার্জি আই টেক ইট আপ at after I come back from my I mean
May I
at
come back at 1
2
o'clock then? my lord?
1 o'clock very well I'll take it up
May I
at 2.
just indicate, my lord, one thing?
Yes.
There is no suppression, my lord.
I'm not saying suppression.
Just a minute. I think my learned friend has finished his submission. Let me just say
Yes, yes,
a few words.
Yes.
My lord, the intervention application,
পল্লবকে বলো এখনি যেন পাঠিয়ে দেয় ওটা I'm
the
sorry. Yes.
intervention application which we are pursuing before the NCLT, we are not saying that we are not pursuing before the NCLT. My lord,
You are
that
appearing for whom?
I'm appearing for the petitioner. The intervention application is disclosed at 537, page 537. My lord, my intervention application could not be taken up for hearing as it could not be listed, and the main petition CP was disposed of before my intervention application was taken up, my lord. That is also disclosed at 580, my lord. And my lord, the proceeding which my learned friend is trying to indicate is a recalling proceeding filed by us for 2 orders. One by which my intervention application was dismissed because when the intervention application appeared, my lord, by that time CP was disposed of. So the NCLT took a stand, my lord, that because CP is disposed of, this intervention is not applicable. For that, we have filed a recalling application, my lord. And the main order, my lord, which was passed before the NCLT on June 26, my lord, which is annexed here, my lord, that was also against us. So we have filed one recalling application for that also, my lord. And that application was appearing. We appeared yesterday, requested the court, let this be adjourned, both the recalling application be appearing together so that it is easier for the court.
One recall application was for the
12th
dismissal of
July,
the
my lord, by which
intervention.
the intervention was dismissed.
The other one for
other one, the
Is-
mean CP, my lord, that is at page 580, my lord. That is at 580, my lord.
Oh, all right.
We have disclosed everything. We are not saying we are suppressing anything. This court has a different jurisdiction, my lord. Here we have come only for the investigation, which NCLT has no power, my lord. We cannot seek that prayer before the NCLT, my lord. We have come, and this investigation is regarding not only one company, my lord. This is regarding more than 200 companies. We are seeking that investigation.
Now that my learned friend has finished, my lord, I will not, my lord, come back at 1 o'clock. I'll say, take only 1 minute, my lord.
Mr. Banerjee, I'll keep it on Monday for passing orders.
My
My lord,
because,
may I say, take 1 minute.
Yes.
My lord, now it has come out from his mouth, my lord, that the recalling application he has prayed for yesterday, he has asked for both of them listing. Paragraph 42 says that they are not being taken up. So, my lord,
It
therefore,
was earlier, my lord.
I
It
don't,
was taken up.
I
This
don't,
was-
I
this-
don't
my lord,
interrupt.
this
I
was
don't
earlier.
interrupt.
Intervention application could
finish.
not be taken up,
Let
my
him-
lord.
let him-
That is what is pleaded there, my lord. My lord is trying to disgrace from the, he's trying to deviate from the issue, my lord. That intervention application could not be listed before the
Take
main
it, let me
CP
hear
was
it now. Yes, I've heard.
heard.
My lord, now he says that, my lord, yesterday when the matter was taken up for restoration, he has asked for the recalling application also to be taken up.
Yes.
Now, my lord, recalling application, if it is taken up, then, my lord, is paragraph 43, what he stated that the NCLT is not taking up matters, that is solved. Now, my lord, to what he has argued before, my lord, that, my lord, 406 is to apply. And I said, now, no, and I stated why. My lord, that is something within the domain of the NCLT. He might, again, my
Hearing
lord,
is concluded,
this
my lord.
practice-
Now
this
he's
practice-
Let him
trying-
argue, please. Take your seat.
So therefore, my lord, it cannot be that the argument of Mr. Banerjee was never that 406 is not within the domain of the NCLT. Now his grievance in 43 is cleared that NCLT will take up the matter. If that is so, my lord, then, my lord, there is no question of having a forum shopping and coming before the writ court. My lord, the NCLT can also, my lord, pass that order because it is within its domain to take up matters under the Companies Act. So, my lord, his grievance at 43 is now solved. It is not that, my lord, he has not taken this point, which we always take, my lord, if our tribunal is not functioning, we have a right to come before the writ court and seek for orders. But that is not the case. NCLT is fully functioning, courts are there. And, my lord, yesterday when the matter was taken up, he has made this submission that the recalling should be also listed. So, my lord, therefore, in these facts and circumstances, this forum shopping should not be done. Maybe he's asking for 200 companies, but that domain is within the jurisdiction of NCLT also. That is my submission. I am not talking about suppression or anything. I have not
You want to
stated
add anything? Add something. You,
Just one.
please do.
That para 40 is regarding non-listing of the intervention application, which was pending, my lord. That's all, my lord, nothing else.
Right.
He's just trying to, I don't know what he's trying to.
Whatever
do.
he's trying to do, let him try.
My lord, most of it.
Grateful, my lord.
Grateful, my.
So, since certain an additional paper has been handed over, which is the cause list of the NCLT, and it is submitted by learned counsel for the petitioner, that even at present, matters are pending before the NCLT at the behest of the petitioner, ওটা learned counsel for the petitioner বলেছে, ওটা respondent হবে।
Respondent number কত? 1, 2, 3.
গোড়াটা একটু বলুন,
Lord, we are respondent number 1, 2, 3.
বলুন আপনি গোড়া থেকে বলুন। Learned counsel for the respondent numbers 1 and 2.
1 to 4, my lord.
Learned counsel for the respondent numbers 1 to 4 petitioner কেটে এবার যেখানে ছাড়লাম ওখানে petitioner, and parties have and learned counsel have advanced arguments on such limited issue, let the matter stand over for a comprehensive adjudication on all points and be listed on August 1, 2023.
My lord, can
This will be at the top of the list. I'll just pass my
My
order.
lord, can it be second? I'm out of station on first.
I'll only pass my order, final order. It has been,
All right.
judgment has been reserved, Mr. Banerjee, and I won't reopen the issue now.
Damage done or no damage?
I have to consider whether damage done or not.
That is what I'm worried about, my lord. How much damage it did, my lord, in my absence.
No, I'll keep the I'm keeping the matter on first. You are in difficulty, I'll keep it on second.
No, what, my lord, can it be? Second, second.
Any day. I
Not
leave
first,
it to
second.
Great.
Most of it.
Great.
My lord, already, that's a separate,
That's on the cost title.
separate remedy, my lord.
Serious, the most serious issue in the matter. It's appearing in the cost title of the NCLT, and your learned junior has ably argued on that. Yes.
Grateful.
Most of it.
My lord, separate remedy.
Grateful. Extension of interim order, item 5.
Yes. Petitioner.
My lord, I appear for the petitioner.
Appearing for the respondents, my lord.
Lord, may I,
My lord, first
Lord, may I indicate, my lord, I am for the petitioner. Lord,
I beg to submit that the writ petition has become infructuous because the tender has already been called up and tender has not been finalized. Nobody was
Let me hear
qualified.
Mr. Singh on this. Yes.
my lord, I had filed this writ petition, my lord, on 17th of February.
Hmm.
Lord, I had challenged, my lord, the auction process where, my lord, I stated, my lord, that I have been prevented because there was a technical glitch on the website and I could not participate. I could prima facie show, my lord, that I was prevented from participating. After hearing the parties on 17th of February 2023, my lord, there was an interim order staying the entire process, my lord, till further orders. This order was passed on 17th of February. Thereafter, matter was heard from time to time, my lord, and finally, my lord, on 19th of May 2023, my lord, the Honorable Court, my lord, had released the matters on the ground that perhaps the court did not have determination, my lord. While releasing, my lord, the order, the matter, my lord, the order was passed that the interim order granted earlier with the order of 17th February 23 shall continue till the matter appears before the bench having determination, my lord. The matter has today appeared, my lord. Meanwhile, Lord, I have learned, my lord, that my learned friends, my lord, Airport Authorities of India, my lord, the tender which was under challenge, my lord, they don't intend to proceed further. My lord, it's subject to what my learned friends say. If that is the case, then perhaps it has become infructuous, my lord, and it may be disposed of recording their statement.
You are the airport authority.
I am for the airports authority. So it has been.
So
Who are you, the successful one?
Government e-marketplace, my lord. That is respondent number, added respondent number 4. And my lord, only on the last occasion, I have filed an exception. My lord, only my lord, let it be, my lord, kept with record. My lord, that
I'll record
recording was
that.
not there.
Very well. Exception টা আছে এখানে?
Yes, my lord, it has to be, my lord, there.
Exception to what?
Exception to.
Should be here, yes.
My lord, the one report I have, my lord, filed. On behalf of the government e-marketplace. That is
Report by
respondent
you
number-
of affidavit on behalf of respondent number 4.
Yes, my lord.
So that's
You are referring to this. This is not an exception.
No, no, my lord,
exception was filed by me.
one.
Yes.
I have, my lord, filed one report on behalf of the government e-marketplace.
Report is there, yes.
My lord, let me not just kept with record.
Did not record that.
No, no, it was not recorded when it was submitted.
I don't think that's now.
But my lord,
No, that's record for other.
My lord, in the meantime, new tender has been called and petitioner participated in that tender also.
That is in respect of some other, my lord, so far this tender is concerned.
Very well, recall that also, if you want. Learned counsel for the respondent, you are for respondent numbers?
1 to 3.
Respondent numbers 1 to 3 submits that the writ petition has become infructuous, comma, since you say the tender has been cancelled.
Yeah, it has been called up as per tender conditions because nobody was
The
qualified.
tender itself has been, the impugned tender itself has been called up, puts up as such, comma, the writ petition, না কি বললাম একবার বলুন তো, writ petition has become infructuous বললাম,
হ্যাঁ,
একবার জাস্ট রিড আউট করে দিন, আমি বলে দিচ্ছি। Full stop. Called up, full stop. Next para, learned counsel for the petitioner agrees to such contention, comma, since the question of further challenge does not remain, full stop. Accordingly, WPA 4166 of 2023 is dismissed as disposed of as infructuous without any orders to cost. Full stop. The report filed on the previous occasion by respondent number 4 be kept on record.
Great.
Deeply
grateful.
Next. ওটা কি ব্যাপার? না তোমার কিছু দোষ নেই, পল্লবকে আমি ডিকটেশন দিয়েছি, এটা দিইনি। না সেটা কি হলো জানতে, আমি তো ওটা ওই জন্য মঙ্গলবার ফিক্স করলাম, তো
Contempt application, item 6 and 7.
Appealing for the first time or you have served already?
My lord, it is heard by your lordship, and my lord, there is a due, my lord, to pay by the, my lord, the alleged contemners, my lord, and in pursuance to lordship's order, my lord, on the last occasion, if your lordship kindly peruse, my lord, the amount has been released, my lord.
Amount has been released.
In his favor, my lord. I have,
So I'll just record that and
my lord, this is the, my lord, copy of the, my lord.
no, need not. You were saying that itself.
Yes, in his account, bank account, it has been paid, my lord.
আচ্ছা রেখে দাও দাও ওটা।
For 3 months and 8 days, my lord. If your lordship,
So I'll dispose of the contempt as infractions.
contempt matter may be disposed of.
Learned counsel for the petitioner submits.
My lord, I am for the alleged contemners.
Oh, I'm sorry. Learned counsel for the alleged contemptor submits that the direction of this court has already been complied with and hands over relevant documents in that regard, which are kept on record, full-stop. None appears for the petitioner, full-stop, in view of the submission of the alleged contemptor, comma,
Paid the amount.
nothing remains in the contempt application, comma, since the amount in question has already been paid to the petitioner, full-stop. Hence, CPAN 149 of 2012 is dismissed as infractuous. No address to cost.
My lord, in this matter, I am led by Mr. Bhaskar Prasad Boisho. He is doing one contempt matter.
He's in court.
He is in court in court number
Very
30.
well, very well. Please give his name also.
Lordship.
Along with connected applications.
Deeply obliged.
Item 8 and 9.
Lordship, I beg
Yes.
to appear for the Milord State Respondent, alleged contempt, Milord.
Yes.
Lordship, Milord, kindly recalls this matter. Milord, there was a direction by your Lordship that these beneficiaries under the Gitanjali housing scheme will have to be given the benefit.
Yes.
Although government, Milord, has stopped the Milord budgetary allocation, Milord, with effect from Milord financial year, Milord, 18-19. So, Milord, by the judicial grace of your Lordship, in granting me some time to comply by allocating fund under some other head, and with the active, Milord, assistance, help of the learned advocate general, Milord, I could get it. The finance, Milord, had already allocated, Milord, the this fund for the entire 22 beneficiaries, Milord, who were there in your Lordship's before your Lordship when the order under contempt was passed. Although before in this contempt application there are 15 out of those 22. Lordship, the order under contempt, Milord, is, Milord, at page, Milord, 21. Kindly see, Milord. 21, Milord, of the contempt petition, Milord, WPA number 198 of 2021. So in this, Milord, order, Lordship was pleased to take cognizance of 22 eligible beneficiaries. But in this content, Milord, out of those 22, 15 have come before Lordship. But, Milord, we have taken the entire 22, Milord, into consideration, and the allocation to that effect, Milord, has been made, Milord, on Milord 27th June, Milord, 2023. Now, Milord, second aspect of the matter, Lordship kindly goes through once, Milord, there are
Your defense was, Mr. Galip, that at the point when the order was passed, even that scheme was not there.
Yes, even your Lordship also was pleased to hold in the order also. There is on record.
Yes, yes.
However, Milord, Lordship, we have done it, Milord. It has
Thank
to
you
be
so
done.
much, yes. And what
Milord,
else?
kindly sees, Milord, the second page of the forwarding letter is the first page, second page, 23rd June. Kindly sees, Milord, the very opening sentence. Administrative approval and release of fund under demand number so-and-so for making payment towards 22 petitioners under the scheme relief to victims of Ayla cyclone. This is a short and long, Milord, and the second next page kindly sees they have allocated this, Milord. And Milord kindly sees the forwarding letter, Milord, at the top. This the DM is giving to us that here we informed that the housing department to the government of West Bengal has sent the allotment for giving financial assistance to 22 number of petitioners related with the above
So,
case.
Mr. Galip, what do they have to do to get this?
Now, Milord, what comes into picture, out of those 22, Milord, Lordship, out of those 22, 9, Milord, sorry, 6 milord have already been given benefit under the milord Pradhan Mantri Awas Yojana. Milord, this milord, list milord, I'm just handing over. Lordship will get 3 sheets in this bunch of paper, milord. Kindly see the last sheet, milord. Last sheet of your lordship's milord bunch of paper I've handed over. The 6 persons who are not there before your lordship in contempt have already been given benefit under Pradhan Mantri Awas Yojana.
So they have not filed the contempt application?
No, they are not before your lordship. And milord, so far as the 15 petitioners in these contempt applications are concerned, milord, 13 milord are entitled to get the benefit under this scheme. And milord, that is the first 2 pages.
What about the other 2, Mr. Galib?
And other 3, as I am told, milord, that they are in the beneficiary list of Awas Plus. That benefit is yet to come. 60-40 ratio, 60 given by the central government, 40 given by the state government. So are yet to come. So those petitioners, if I'm to point out, milord, from the cross title of the contempt, lordship kindly comes to the cross title of the contempt, milord.
Mr. Galib, what happened to the appeal? That appeal has been disposed of.
That appeal was relating to a separate set of petitioners. These 22 were not part of that. That was regarding other 48 benefit, 481.
What happened there?
Still now pending, and we are on the process of complying that also. That also, lordship. Allocation has been made.
So if you have a fresh cause of action, then file a fresh.
So one thing, lordship, my lordship. So far as milord, 1 to 8 petitioners, they are getting 1 theke 8. 9 is in the Awas Plus.
Mr. Galib, please put this on a short affidavit. I'll take all these on. These are factual aspects. Just put in a short affidavit whenever you can.
With due respect to my learned senior friends. So my lord, this is the order which has been passed.
See, in a contempt, we cannot go further.
I am not on that. Because of that, our 2 names has been included in 2022. But the order which has been passed in 2019, I am not, my lord, praying for Awas Yojana Prokalpa, any scheme, any benefit. I am entitled to get the Gitanjali.
Gitanjali was not there.
2019, that's why lordship consider. Second round of writ petition. I have come before.
Learned counsel for the alleged contemners seeks to rely on certain documents to indicate that the alleged contemner has already made necessary arrangements for grant
of funds.
Necessary arrangement na kore necessary allocation of funds from other schemes of the government, in order to disburse the amount which the petitioner sought under the Gitanjali scheme, to the petitioners. First up, however, it is submitted that out of the 22 petitioners who had made the original writ petition, some
15 writ petitioner was there originally.
Not 22.
No, that is a separate writ petition. That is also my petition. That is here in my writ petition 15.
Well, it is further submitted.
21.
Since the alleged contemner seeks to place reliance on certain documents, the alleged contemner is directed to file an affidavit annexing such documents and pleading the necessary facts in that regard. In such short affidavit, first up, the said affidavit shall be filed on August 8, 2023, when the matter shall be listed. First up, an advance copy of the affidavit shall be handed over to the learned counsel for the petition. 8th of August, I've given you 2 weeks time, almost 2 weeks time, Mr. Gali. File a short affidavit, we will consider this.
Lordship.
I'll keep something on record. Because the contempt cannot go on and on.
No, lordship order. I am going to direct it to the authority concerned to release after considering the order of the BDO.
Next matter, please.
Grateful to lordship.
Item 10. Item 10.
Yes,
supposed to put in my reply to 2 sets of oppositions to my contempt application. I could not do it. May I have a fortnight's time now to put in the reply?
I am for the contempt number 5 and 6.
I appear for contempt number 1 to 4.
You are for the petitioner.
I am for the petition.
Reply, you are saying.
Reply.
Oppositions have been filed by
Yeah,
you.
file my opposition. Two sets of opposition.
So when should I keep it?
My lord, may it appear after a fortnight?
After?
Fortnight, my lord, subject to my list convenience.
Learned counsel for the petitioner submits that due to certain inconvenience, comma, the replies could not be prepared, full stop, on the prayer of the petitioner, comma, the time for filing reply is extended till August 11, 2023. Full stop, the matter shall be listed on August 11, 2023 under the same heading. Please come back on that date.
My lord, my inability was unavoidable. My lord, I could not do it. My lord.
Obviously it was. Yes.
Great. Great.
আগেরটা
না 12
8 অগস্ট ওটা কি শুক্রবার দিন পুরো দিন আগেরটা তো হ্যাঁ হ্যাঁ এইটা 2 সপ্তাহ দিয়েছি
Item 11.
Yes, Mr. Bajpai, what have you done?
My lord, we have already
I'm appearing on behalf of the petition,
compliance
Lordship.
report. We
Led
have
by Mr.
fully
Ujjal Rai.
complied with the order.
Yes.
Even by recalling the holidays that they had grievance.
Lordship, the calculation sheet has already been provided to us and the matter may be disposed of, Lordship. Subject to,
Thank you, sir.
Lordship kindly grants liberty. If the calculation sheet is not as per the law, Lordship, I may have the liberty to go before the appropriate forum, Lordship.
So that liberty is always there.
Very well put in, sir. Learned counsel appearing.
Oh, Lordship, I have another submission to make, Lordship. I have been issued a decategorization certificate, but I'm still continuing in the post of constable.
No. That has been decategorized. He is in a supernumerary post has been created. Possibly my learned friend is not aware. And that was not the subject matter of contempt.
Learned counsel for the petitioner submits that the amounts in question have already been disbursed to the petitioner and a calculation sheet has been handed over to the petitioner. Full stop. Although otherwise the grievance of the petitioner in the contempt application has been mitigated, comma, it is contended that the petitioner be given the liberty to challenge the calculations, comma, if so required. Full stop, next para. Upon a perusal of the compliance report as well as hearing the submissions of the parties, comma, it is evident that the cause of action for the contempt has since been mitigated by compliance of the order of this court by the alleged contemners. Full stop, hence, comma, WBCRC 96 of 2023 is discharged and WPA number 8620 of 2021 stands disposed of without any orders to cost. Full stop. Liberty is granted to the petitioner, comma, in the event any subsequent cause of action arises for challenging the calculation or otherwise, comma, to prefer an appropriate writ petition on such score. Thank you, Mr. Bajpai. Yes.
I am grateful, my lord.
I'm led by Mr. Ujjal Rai. Should I?
He's in court.
He's in court.
12 and 13.
Lordship, this is my application, Your Lordship. I'm being led by Mr. Ronidwan Kaur, Your Lordship. My Lord, Mr. Kaur is suffering from high fever, my Lord. I'm praying for 1 week's accommodation, Your Lordship.
For the petitioner?
Yes, Your Lordship. This is
And for
that
the
rent control matter, Your Lordship.
On the prayer of the petitioner, the matter is adjourned. Till when? Tell me.
Next, let it be taken on next Friday, Your Lordship.
Till August 4th, 2023.
Grateful, Lord.
Thank you.
I'm being led by Mr. Rai.
Only rule is they have to be in court.
He was there in the morning.
Whoever, yes.
14 and 15.
I'm for the petitioner.
Yes, please. Service?
First time application, Your Lord.
Pardon?
I appear first time as contempt application.
Oh, this is a contempt.
Contempt.
What is the contempt alleged?
Contempt, Lord, direction has passed to evict the unauthorized occupant. And kindly see the page 35. They have found it that there is unauthorized occupant and directed SDU to take steps in accordance with law, but subsequent no steps has been taken. Annex E page 35, my lord.
No, what was the direction given by court?
DX1 my lord, page 20.
I mean, what is the contempt? That is what I'm asking. Or to inquire into unauthorized occupation. To inquire into the question of unauthorized occupation.
Yes,
That
my
was the direction.
Unauthorized public land.
Yes, it's obviously public land. Let us come to page 35 now.
Page 29.
35 or 29?
35 is the
29 I have seen. Yes.
35 is the findings that there is unauthorized occupant and to take steps in accordance with law by the SDO. Subsequently, just notice of content has been served, page 37, Annexure F, for compliance with the solemn order of the Honorable Court. And that has been duly received, which is evidence of track record of delivery, page 40. But in spite of that, no steps yet has been taken to take steps as per West Bengal Public Land Eviction of Unauthorized Occupant Act.
Learned counsel for the petitioner submits that in violation of the specific direction dated July 7, 2022, passed in WPA 11361 of 2022, the respondent authorities, despite having found that the private respondents are in unauthorized occupation of public land, have not taken any steps for initiation of proceedings under the appropriate statute. Full stop, next para. Since a prima facie case has been made out by the petitioner shall serve copies of the contempt application on the alleged. How many contemners are there?
3 million.
On the alleged contemners, indicating that the matter shall be listed on August 14, 2023, when the petitioner shall file an affidavit of service. Let us see if in the meantime they do something. Yes.
Yes.
16 and 17.
I am appearing for the respondent.
This is the case where a minor was electrocuted to death and his father was the writ petitioner.
Yes. Your Lordship was already passed an order in respect of that contempt application, and we have preferred an appeal, but the appeal could not be heard. Lastly, my lord,
appeal against the order passed in the contempt application.
No, that
main
is
order.
Main order. And lastly, my lord, this order was passed on by the appellate court on 15th June, and thereafter, my lord,
stayed.
No, my lord, what happened? What happened that we have filed the appeal with the leave of the court, but the Honorable Justice Division Bench held that leave of the court will not suffice. You will file along with the certified copy. In the meantime, we have already filed the certified copy in the department. Then we next.
So here you had not filed any application for condemnation of appeal.
In that in initial because it was filed without certified copy because certified copy was not delivered to us. Subsequently, that leave was granted to take back the certified copy.
What is the situation now? You have filed the section 5?
We have filed the section 5 along with the fresh appeal as per my lord, their division's bench order, and thereafter my lord, matter was yesterday item number 26, but up to 22 it has been raised. This is the very unpleasant situation for me.
But perhaps it's the conduct.
Direct the division bench to here.
Well, kindly see the conduct. They go for pressing they press the appeal without section 5.
No.
I had pointed out before your lordship that there was no section 5 application.
It's the usual conduct of the WBCD. If it was otherwise, Mr. Banerjee, then it would be suspect.
And what in the meantime, they may at least assess the quantum. That can be done. And one more thing I would like to remember, there was a direction for paying cost. On the last occasion, that was done by one of my learned senior friend. Had the
from your pocket?
Yes. Had they been reimbursed?
As per their,
I'll want to see the receipt, Mr. Rai, that it has been reimbursed.
So it has been directly in their bank account.
I want to see your statement.
Yes,
no.
yes. That
may reveal some other things, Mr. Rai.
No.
No, very well. Learned counsel for the alleged contemners submits that initially there were certain defects regarding filing of certified copy in connection with the appeal against the parent order. Subsequently, such defect was cured. However, the concerned division bench dismissed the appeal on the ground that there was no application for condonation of delay. Full stop. Subsequently, applications for condonation of delay has been filed, comma, which is now pending and with the appeal before the appropriate division bench and has been enlisted before the said bench. Full stop. Hence, comma, in order to enable the alleged contemner further time to bring an appropriate order from the appellate court, comma, the matter is adjourned till August 7, 2020, August 11, 2023, when it will be listed under the same heading. 2 weeks time, Mr. Rai, please
I
do something. Yes.
in the meantime, it will be because it is well, not last 26.
Sections 5 will probably be allowed, but after that, you move your stay immediately. Otherwise,
Yes, yes.
Section 5 also might not be allowed. That is subject to a different code.
anyways, let him not disclose his defense in the section 5. Yes. দেখো সকাল থেকে এসে ওহো বলা হয়ে গেছে থাক এটা টু বি মেনশনটা দিয়ে দিও টু মেনশনটা দিয়ে দিও ওটা বলে দিও বা ওই দিন দিয়ে দিও 14 অগস্টে দিও ব্র্যাকেটে আর আমাকে মনে করে দিও যাতে তুমি না ধাতে নিখাও দেখেছো এটা
18 and 19.
Yes.
Your Lordship, on the last occasion on 21st of July 2023, Your Lordship had given us liberty that the present special officer shall file a report as to about the medical health of the erstwhile special officer who had suffered carcinoma for 1 year and he was under chemotherapy. Your Lordship,
The petitioner,
his
Your Lordship directed me to find supplementary
What is this?
service. I am finding the affidavit of service, my lord. No report was served upon me.
Give a copy to him. A report is filed today on behalf you are for the election.
alleged contempt number 1 and 3, Your Lordship.
I appear
for election commission.
Right.
My lord, I have only one submission, my lord.
Yes.
Kindly see the, we have received a letter from the newly appointed officer, ARO, returning officer, from where an estimated cost reveals 14 lakhs, my lord, for 14 lakhs something for
Your Lordship had directed to prepare a
none of
list.
What was the allegation of contempt?
Well, the allegation of contempt that they have not complied with your lordship's order.
No, obviously that. I mean, what order?
Your Lordship,
No, my
they
lord,
had to
kindly see,
prepare a
my
voter
lord,
list.
kindly see. My lord,
Let me hear him first. Let me hear his defense first. I'll come back to you.
Your Lordship,
Yes.
Your Lordship's order was of 22nd of April 2022, which is at page.
This was regarding election of the
Your
cooperative
Lordship,
society.
a
Yes.
housing cooperative society. It's a plot-based housing cooperative society, Your Lordship.
What is the contempt you committed?
33, they are alleging, Your Lordship, there has been a delay.
Take the mic.
Your Lordship, there has been a delay. The reason for which I have already explained by giving the medical reports, Your Lordship, the erstwhile special officer who was directed to prepare a voters list and to assess the cost for the elections, because on the earlier occasion, there was an order of the Honorable Division Bench, wherein the Honorable Division Bench has directed that the cost for conducting the elections has to be paid by the members of the society, Your Lordship. Considering that order, Your Lordship had directed that the special officer shall prepare a list of members and assess the cost, estimated cost to conduct the elections and hand over the copies of the estimate to the petitioners, and the petitioners shall generate the funds and
Then
go for the elections, Your Lordship.
No,
What
but-
happened in meantime, Your Lordship, just after passing of this order, Your Lordship, the then special officer was detected with carcinoma in the lungs and all, Your Lordship. He had gone under chemotherapy. I have enclosed the medical documents, Your Lordship. Thereafter, we have appointed a new special officer, Your Lordship, who has taken steps to assess the estimated cost, Your Lordship. What I have learned, Your Lordship, that this estimated cost was communicated to the petitioners of the contempt application, Your Lordship. 7 envelopes have come returned, Your Lordship, as addresses could not be located, Your Lordship, and 2 have been received by them. Now the thing is that, Your Lordship, this estimated cost has been derived because the member list which was earlier prepared in the year 2019 by directions of the Honorable Division Bench, Your Lordship. Thereafter, when the elections have to be conducted, Your Lordship, there was COVID period, and Your Lordship will remember Your Lordship had passed an order in the cases of plot-based society, Your Lordship.
Was there a direction to file affidavits?
Your Lordship, of report was to
In
be
the
filed.
contempt application, I directed to file a report.
Your Lordship, 21st of July 2023.
On
Sorry,
that
Your
day I
Lordship.
was absent. I was
Your Lordship, kindly only recall one thing. Your Lordship had passed an order that in cases of a housing cooperative society where the petitioners failed to construct a building for more than 3 years, Your Lordship, that plot gets cancelled.
Give a copy of the report to them so that they
Your
can
Lordship,
consider.
that order has been upheld by the Honorable Division Bench, Your Lordship. The law which is at section 88, Your Lordship, that if a person keeps the land 3 years vacant, Your Lordship, then the land can be cancelled.
Contempt here only to see whether this can be
They have to file
done
the
sufficient to avoid contempt, basically.
One
So-
only thing, my lord, let me show you.
No, unless you look into the report, what is the use of hearing you piecemeal,
No, no,
again
no.
hearing you on the next occasion? What is the use of
But
this?
we have already.
Look into the report, come back with a comprehensive argument. You give me a date, I'll keep it on that date whenever you are ready.
My
Any
lord,
date. And
even-
it has to be a Friday. I'll keep it next Friday.
My lord, my lord, we have to.
A copy of the
consider
report is being handed over.
And if we may I
Exception.
exception.
Very well. When should I keep it? Tell me. Give me a date.
1 week.
Either next Friday or Friday
next
after that.
Friday, day after, next Friday.
She is
1 week
asking
or
for
2 weeks?
Fortnight, Your Lordship.
Fortnight.
Learned counsel for the alleged contemner numbers 1 and 3
Your Lordship.
files a report which is kept on record. Full-stop, a copy of the same is also handed over to learned counsel for the petitioners. Full-stop, to enable learned counsel for the petitioners to take instructions and to file an exception, comma, if so required, comma, the matter is adjourned till August 11, 2023. Full-stop, exception to the report, comma, if any, comma, shall be filed by the petitioner on the next returnable date with an advance copy of the same to the learned advocate appearing for the alleged contemner numbers, alleged contemners. Full stop. Yes.
Your Lordship, only one thing, Your Lordship, this report has been filed by the present special officer, not the alleged contempt number 1 and 2, Your Lordship.
Acha.
Your Lordship, this liberty I had taken.
Very
in the
well.
last-
তাহলে একটুখানি যেখানটা বললাম না উঠতে হবে না, জাস্ট রিপোর্ট ফাইলড বাই দি অ্যালিস্ট কন্টেম্পট বললাম না,
The present special officer.
report filed by the present special officer, comma, who has assumed charge in place of the
Contempt number 3.
alleged contemner number 3,
Grateful.
comma, in view of the latter apostrophe's serious ailment. Thank you.
Gratefully.
And give me a tentative date on the next occasion, please, on instruction, how soon you can conclude the thing.
The moment, Your Lordship,
An approximate.
Lordship, the
My
moment
lord,
they
the
give
excessive-
give the amount which has been assessed, Your Lordship, I think what I was talking with Mrs. Das, that they have a problem with the amount which has been assessed, Your Lordship. We also have a view, Your Lordship, if Your Lordship
You can
directs.
sit together and
Your
resolve it.
Lordship, and there can also be a way, Your Lordship, we can only tell them that you have to do this. They can directly pay that money to the concerned.
Yes, and you can cut costs also if they want it, their
Your Lordship,
election. Yes,
Only thing
on cuttable.
We are
things,
flexible,
yes.
Your Lordship.
Very
Yes.
flexible. Next.
2021.
My lord, I am appearing for alleged contemner number 4.
Yes, Mr. Bhattacharya, what is the cause? Yes.
Lordship, in this matter, Mr. Fotik Chandra Das is appearing on behalf of the petitioner, Lordship.
Please use the microphone, Mr. Bhattacharya, can't hear you. Yes.
Lordship, Mr. Fotik Chandra Das is
Yes.
appearing on behalf of the petitioner, Lordship. He is before the circuit bench, Port Blair. He is not present today, Lordship. Kindly take up the matter next Friday, Lordship.
But I appear for my lord, the election commission.
Yes, Mr. Bhattacharya, next Friday on the prayer of the petitioner.
My lord, I am in Mumbai for treatment of my wife. Then in that case, my lord may extend it for another week.
Very well. Sit up on the Friday after that. Yes. On the prayer of the petitioner, the matter is adjourned and shall next be listed under the same heading on August 11, 2023.
Only one indulgence may pre-lordship on the last occasion. On the first occasion, will there be direction for filing affidavits. I have served in affidavit, they have filed reply also. May I hand it over to lordship.
This is the affidavit in opposition of
Affidavit in opposition, lord, on behalf of
container number 1. আরেকটা লাইন অ্যাড হয়ে যাবে, the affidavit in opposition filed by alleged contemner number 1 today be kept on record.
My lord, the affidavit in opposition on behalf of the alleged contempt number 4 is there. My lord, a junior colleague of mine is there. My lord, may kindly accept it.
Number 4 or 2?
Number 4 I am appearing for.
তাহলে alleged affidavits in opposition, alleged container numbers 1 and 4.
Grateful, my lord.
Thank you.
And Lordship, in that case, I'm also filing my affidavit in reply.
Why are you doing it piecemeal? Do it together. This is the reply. To which one? There are 2 oppositions. আরেকটা লাইন অ্যাড করে দিন তাহলে তার সঙ্গে a composite affidavit in reply filed by the petitioner be also kept on record. Thank you.
ডেটটা কবে হলো?
22.
My lord, 22, I am appearing for the petition.
Yes.
Lord, I appear for
Order in contempt is at page 37, man.
Court number 29.
So, pardon, my lord, it's 32. 32 is the operating portion.
Yes.
There is direction upon the WBSCTCL to shift the line and to seek police assistance if they receive any hindrance.
Yes, Mr. Naik.
My lord,
Police costs were assessed. We have put in the police cost. They came to the local, but the work has not been completed.
Yes. But
my lord, let me have a just copy, lordship.
With first time, this is a very first time for the
Lord, no copy was served, my lord.
It's
If I have a
appearing for
copy,
the
I am
first
coming
time.
with the report.
Learned
A copy
the alleged
नहीं copy, just go to
the
the 2 contempt, 3 contempt.
Initially, we did not have any objection. We tried our
alleged
best also.
container number 1.
Justify,
You are appearing for 1, the WBSCTCL person.
Lordship. My lord.
The alleged container number 1 is
Only one,
represented through
one.
counsel, footstep. Let a copy of the contempt application be handed over to said counsel, footstep. The petitioner shall also serve copies of the contempt application on the alleged container numbers 2 and 3 and file an affidavit in that regard on the next returnable date. The matter shall be taken up for hearing on August 11, 2023.
Grateful, lordship.
Top item, item 23.
My lord, in item 23, I have been instructed to submit that Mr. Debanjan Mukhopadhyay, learned advocate, is appearing on behalf of CS Limited.
Yes.
My lord, there is some personal reasons he will not be able to attend this honorable court today, my lord. There is
Lordship.
medical reasons, my lord. He will not be. So I'm praying for not today only, my lord.
Lordship, kindly see, for more than 20 years, because they are so powerful, in spite of the order of the Supreme Court, they have not supplied electricity to me. I am compelled to operate generator, spending lots of money. Lordship, you see the last page. They are taking time. Since the appeal is dismissed and the application has
No.
logically see the order of the Honorable Supreme Court. So 1 2-page order. At page 38. Order. The appellate here is is a licensee under the Indian Citizen Act and so on the agreement that with the Calcutta Municipal Corporation providing electrical energy to the buildings and known Alipur, New Alipur market. The order respondents are shop owners who are there carrying on their business. When the matter was taken up for hearing, parties to this appeal arrived at an agreement in terms of the court.
Mr. General, I'll give them a last chance since he's not here. I'll give them a last chance. I'll keep it fairly at the top of the list on Monday. Learned Counsel, an adjournment is sought on behalf of the CSC Limited. Footstep, Learned Counsel for the petitioner submits that despite a specific direction of the Supreme Court passed as long back as on February 20, 2001, the respondent licensee has not given electricity to the petitioner in terms of the said direction. Full stop as such, comma, it is pleaded that the matter is extremely urgent. Full stop next para. Be that as it may, comma, in view of the prayer for adjournment made by the CSC Limited, comma, the matter is adjourned as a last chance to the CSC Limited to represent its case and contest the matter, comma, till July 31, 2023, when the present writ petition shall be listed fairly at the top of the list.
Grateful.
I'm deeply obliged, my lord.
Well, in
Please ask
spite
your
of,
Lord. Yeah.
in spite the order of this honorable court, my lord, H.B. Sinha, my lord, they have not paid, my lord, 200 games since then, since
So
1990.
Jana, reserve your energy for the next day.
No, my lord.
Yes.
My lord, because they are so powerful, they do not care to Supreme Court and Honorable High Court.
They are power suppliers, power distributors. They have to be
No,
powerful.
They have
By
power,
definition, they are powerful.
supply,
Yes.
my lord, they are almighty because they are supplying power.
I'm obliged, my lord.
Grateful to everyone.
24.
Yes.
I appear for all the respondents. But I am appearing for the petition, Madam.
Yes. Yes, Mr. Mondal, what is the matter? Chakravarti, please take it. Yes.
This is a freedom fighter matter, Madam. Here, the husband of the petitioner was a freedom fighter, Madam. He applied for freedom fighter pension.
Now I am getting apprehensive, Mr. Mondal. Are these genuinely genuine people?
Yes,
So many applications are coming up after one order is passed. Others are filing applications and all this.
No, my lord, this application has been filed in the year 81, my lord. If your lordship can please.
Tell you lost only one. The certificate on the basis of which this claim is made, that has been questioned by the Honorable Supreme Court and this Honorable Court.
Again, that person.
R.N. Giri. An investigation has been directed to.
I'm tired of Mr. R.N. Giri, Mr. Mondal.
If your lordship kindly.
His
may I apprise
certificates
this
are being
on
questioned
this?
by the Supreme Court every time, and his certificates
I'm
are the
giving
only
answer.
certificates which are being relied on.
No, my lord, there are several certificates. They are.
Then I'll direct
almost-
them to file affidavit in opposition so that they can disclose all these documents.
Can you see para 16?
No, very well, I'll see it since you're handing over. Yes.
Actually, your lordship can.
Rules also of the Supreme Court.
With due respect to
Several
my
matters.
senior, what I am submitting, my lord, from 2019, this matter is pending before the Honorable Supreme Court, my lord. Even on the last 17th of this month, my lord, that was pending, and 11th of this month, the matter was taken up. And lastly, the matter is fixed on 22nd of August, my lord. So what I'm praying, my lord, they have been repeatedly directed to file a report, and they have been taking time on that score.
I'll
But
keep it, Mr.
till
Mondal,
date,
after
if I can
22nd.
apprise your lordship,
I'll keep it
the
after
last-
22nd August. Let us see what happens there. If they don't file a report, then we'll proceed on the premise. I'll direct affidavits in the meantime. Yes.
2nd August.
Learned counsel for the petitioner submits that the petitioner, comma, despite being entitled to freedom fighters pension on account of her deceased predecessor, your deceased husband.
This is husband.
Deceased husband, comma, the same has not been disbursed by the respondent authorities. First of next para. Learned additional solicitor general appearing for the Union of India contends that the person on the basis of whose certificate, comma, being allegedly a freedom fighter, comma,
May I
has been questioned as a freedom fighter even before the Supreme Court.
Your lordship,
Full stop,
kindly,
next para.
I would like to.
As well as by this court. Full stop, next para. Such contentions are disputed by learned counsel for the petitioner, be that as it may, comma, since factual questions are involved. The respondents are directed to file their affidavits in opposition within 3 weeks from date. Full stop, reply, if any, shall be filed within 1 week thereafter. The matter shall be listed for hearing on August 28, 2023.
Your lordship, kindly bear me for 1 week.
Yes, এটা ফেরত দিয়ে দাও,
Lord.
Mr. Chakravarti, Mr. Bhattacharya. Yes.
Here,
Yes, Mr. Mondal.
if your lordship can takes up the brief for a moment, my lord. If your lordship
no,
can, no, just a minute, my lord. Your lordship,
Why?
here, because what they have said, my lord, they are
Obviously, you're
questioning
denying, I've recorded, you're denying.
No, they are questioning this question of certificate, genuinity of certificate. My lord, is they have a challenge here? What is the ground of
Call on the next
rejection,
matter,
your lord?
please.
Grateful to you.
25.
This relates. Give direction for filing of the affidavit within 4 weeks, because this is Under Secretary Department of Home has to upon the affidavit. New Delhi.
Mr. Mondal, yes, Mr. Mondal, 4-1. Very well. তাহলে ওটা আগেরটা affidavit operation within 4 weeks, reply within 1 week thereafter. The matter shall be listed on September 5, 2023 for hearing. 5th September.
My lord, allow me to give your lordship a short background.
Yes, please.
My lord, import of timber. My lord, when timber is imported into India from any other country, which is the country of origin, my lord, the timber is required to be sanitized or the exact word is fumigation. My lord, the substance, the chemical substance which was used earlier was called methyl bromide. My lord, thereafter World Health Organization held a Montreal protocol where all countries participated, and it was held that methyl bromide is a ozone depleting substance. So methyl bromide has to be stopped from being used by all countries. So gradually, my lord, all countries, developing countries, stopped using methyl bromide as a fumigation agent, and the alternative was aluminum sulfate. Now, my lord, India, surprisingly, my lord, all timber which is imported, my lord, there is a certificate which is required to be obtained from the country of origin. It is called the phytosanitary certificate. So, my lord, this inspection of the imported goods which it takes place, the timber, they insist on the phytosanitary certificate. And the Indian, my lord, counterpart, they insist that it should be fumigated by this particular agent which has been phased out from all over the world. Well, there was an issue at that point of time.
The fumigation is done at their point.
At that point. Now they are now insisting, there were two issues, that it should be fumigated here if it is not fumigated by methyl bromide there. So well, this was under challenge before all high courts in India. And then eventually, my lord, orders were passed by various high courts. And it was held that they were charging a 5 times penalty if it was not fumigated by methyl bromide. Surprising and it sounds ozone depleting agent, but eventually it was held that this penalty cannot be charged. It is arbitrary and unconstitutional. Well, eventually a judgment came by the Madras High Court, but this methyl bromide concept continued. Well, thereafter, my lord, office memorandum by this department, which is the Plant Quarantine Department of Government of India, well, lord, they have issued office memorandum from time to time, and now they have included countries which are known as the phased out countries, where usage of methyl bromide has been phased out. So if there is an import of timber from these phased out countries, then they don't charge penalty and they give a let export order, or which is basically, I mean, it is released for home consumption.
Phasing out is pertaining to the methyl bromide.
Methyl bromide only. So methyl bromide, if not used by the country of the exporting country, so then they start releasing it. So my lord, the list has been prepared of the countries which has phased out from time to time. Now, my lord, the list was prepared in 2019, which included 57 countries. Well, thereafter, my lord, in 2021, another list was prepared, which included a country by the name of Suriname, which is in the Republic of Caribbean.
I remember from the
Caribbean
stamps.
islands. Yes.
I remember from the
Yes,
stamps.
yes.
Yes.
In the younger days, we used to collect stamps.
Yes.
So, well, my lord, this country was included in the list which was prepared by the central government 2021.
Right.
Now suddenly 2023. Now, my lord, now they have come up with a notification that some of these countries have not apparently provided to the government of India the authenticated documents on the basis of which government of India can include that country in a phased out country. Well,
To show that they have actually phased out.
Phased out.
So they have not produced those documents.
That's what the government of India, this is the stand of the government of India. But they have already included those countries in the list. So office memorandum has been published on the 6th of June, which is under challenge. 16th of June. My lord, even the 16th of June notification has been challenged by all the several other high courts, including the my lord, Gujarat High Court, where it has been stayed. My lord, the purport of this office memorandum, if I just draw your lordship's attention to one or two of the previous office memorandums, which will give your lordship. My lord, previously, this same association had filed a writ petition in which, my lord, an interim order was passed. This was confined to though that 5 times penalty. So I'm not bothering your lordship, but I'm just indicating it is at page 39. Now, if your lordship kindly takes page 46.
Yes.
My lord, this is a notification of 13th October 2022. My lord, here, if your lordship kindly takes, this is based on that plant quarantine regulation of import into India order of 2003. My lord, an amendment was brought if your lordship takes paragraph 2 of this notification.
Yes.
In chapter 2 of the plant quarantine order of 2003, after the existing entries relating to clause 5 of the following entries will be added. Now, my lord, your lordship will see that in case of consignments requiring pre-shipment fumigation with methyl bromide, MBR is methyl bromide, originating from countries which have phased out the use of methyl bromide for quarantine and pre-shipment purposes, the consignment shall be released after charging the normal inspection fee. The NPPO, well, this is the officer which is National Plant Protection Officer of the country, will be required to submit relevant documents to NPPO India to established phased out status. NPPO India would notify the list, which would be updated regularly based on the information received. Now, if your lordship kindly turns to a list which is page 48.
Yes.
49 48 is another office memorandum which is of May 2023.
This refers to that.
Yes, and this refers also to a list which is there at the next page.
Right.
My lord, kindly take the second paragraph of this office memorandum, which starts with consequent to this, NPPO India has communicated to 194 IPPC member countries and sought for methyl bromide phased out status for quarantine and pre-shipment purposes with document evidence. On the basis of response received from various IPPC member countries, the list of methyl bromide phased out country status for quarantine and pre-shipment purposes has been compiled, and the same is furnished as Annexure 1. My lord, your lordship kindly turns to page 49.
Mr. Bose, I'll come back at this.
Thank you.
Yes, Mr.
My lord, I was at page 48.
Yes. We are going to go to 49. Yes.
Yes. Now, may I just trouble your lordship once with one sentence of 48 before I take your lordship to 49?
Yes.
My lord, consequent to such and such, NPO India has communicated to 194. My lord, IPPC is, my lord, the International Plant Protection Convention countries.
Yes.
Member countries, and sought their methyl bromide phased out status for quarantine and pre-shipment purposes with document evidence. On the basis of the response received from these various IPPC member countries, the list of methyl bromide phased out country for such and such pre-shipment has been compiled and the same is furnished as Annexure 1. In view of the above, you are directed such and such. Now, my lord, your lordship will kindly turn to page 49, which is the list of countries which was published on 10th May 2023. This is the list prepared on 10th May 2023 and published pursuant to this office memorandum. Here your lordship will find that serial number 39, Suriname is there. So, my lord, I am an importer of timber. So I import from Suriname on the basis, regular import from Suriname. So, and it has a phytosanitary certificate with methyl bromide. So it's a phased out country. Now, my lord, your lordship will kindly turn to the impugned memo, which is at page 50.
Yes.
My lord, this refers to the Gazette notification of October 2022, by which it was decided by the central government that this is the manner in which we have to, from time to time, update the phased out countries and publish their names. Now, my lord, kindly take para 2. In continuation of this, NPPO India has communicated to 194 IPPC countries, which was there at the previous, my lord, office memorandum, phased out status for quarantine and pre-shipment purposes, along with the copy of relevant documents such as Gazette notification, resolution, decree, or any legal document as evidence. In response to this, till date, 53 NPPOs have replied their methyl bromide phased out status. However, some of these countries were just replied through email without submission of desired document, and few of these countries have submitted their official letter without submitting the copy of the Gazette notification, resolution, decree, or legal documents for phased out methyl bromide. The letter documents submitted by some NPPOs are not in English, which require translation. This is leading to delay in finalizing of methyl bromide phased out list of countries, due to which many import agricultural consignment at various Indian ports are held up for want of import release. Now, my lord, considering the above ambiguous situation, competent authority, DA and FW, has decided to grant 2 months' time till 31st of August 2023 to consolidate and finalize the list of methyl bromide phased out countries as per the requirements specified in the Gazette notification of 13th of October 2022. During this time, that is till 31st August, the competent authority has approved to allow the import of all agricultural commodities without offshore methyl bromide fumigation from the 57 countries, 57 phased out countries communicated with a directorate letter of 20th May 2019. After charging normal inspection fee, then in accordance with the directions issued by such and such dated 12th October 2022, however, the list of methyl bromide phased out countries circulated with a directorate office memorandum of 17th May 2023 will be discontinued till 31st of August. So, my lord, retrospectively, they are discontinuing the countries which has been published and is at page 49. This publication was made in May 2023.
Why? Because my lord, there is a concept of this international transgression where one country, if he is a party to another protocol, you have to accept. So documents have not come to the government from the other country. You have published the name. If your lordship will see page 49, these are published countries' name based on the notification of October. So now today I am in a situation, my lord, I have annexed documents that based on the phytosanitary methyl bromide certificate, I'll just give your lordship one example where what is the situation now. If my lord, your lordship will kindly take the trouble of coming to page 71, which is a bill of entry. Your lordship will just see what has happened or the present situation, what has arisen based on the 16th June office memorandum. My lord, I have imported from Suriname. If your lordship will see bill of entry for home consumption, page 71. Your lordship will see towards the left. Yes. About 4-5 lines, there is something called the IGM, Import General Manifest, dated 13th of June 2023. Immediately below that, your lordship will see country of origin is Suriname. Yes. So now, my lord, based on that May, Suriname is a country, my import is there, my goods are already here. And you have given them 2 months time to give it. But what you've done is that you've said that now you go back to those 2019 countries. Now, 2019 country, surprisingly, does not have Suriname as one of the countries. Suriname name was incorporated based on the phased out countries in May 2023. So, I imported from Suriname based on the phytosanitary certificate. My goods are lying in the port now. They are not releasing it. Why? They will release it. You have to give 5-time penalty or they're not releasing it. And when, the entire object is what? Methyl bromide, which is a ozone depleting agent, and it has been phased out all around the world. Now, my lord, your lordship will see even this office memorandum of 16 June was challenged before various high courts. We've been able to get an order from one high court, which is at page 91. July 10th, 2023. A similar situation had arisen page 91, if your lordship will see. Yes. Paragraph 3 records the facts where your lordship will find, if I may just place para 3, the petition is an association of timber importers merchant. By way of a present petition, the petitioner herein has paid for direction to forthwith permit the members of the association to clear their consignment of timber from plant protection such and such, whose concern of the country of origin is shipped on board to the office memorandum of 16 June. Issued by the respondent number 2 from the country which are already recognized by respondents as methyl bromide phased out country under office memorandum 17th May without any penalty or any additional fee. Then, my lord, the country of Suriname is also the issue there as well. Item number 39, paragraph 4. Your lordship will see, and placing reliance on submitted petitioner has imported timber from country Suriname, item serial number 39. The aforesaid consignment has reached India. Relief was given under paragraph 7D. Annex for my lord, we have craved relief. There was an order of this Gujarat High Court in terms of para 7D, which is at paragraph 7 at page 93. Yes. So that we have craved leave in the petition. Well, if I may just read out for your lordship's consideration that prayer D. Yes, yes. It just says, your lordship will be pleased to issue appropriate writ under direction, including the nature of mandamus, certiorari directing the respondents to forthwith permit the members of the petition association, timber importers, to clear their consignment of timber from plant protection and quarantine department, whose consignment from the country of origin is shipped on board prior to office memorandum of 16 June. Issued by R2 from the country which are also already recognized by the respondent as methyl bromide phased out country under Office Memorandum of 17th May 2023 without any penalty.
It
addition.
corresponds with your G.
My
It's
G.
your relief G.
My G. My G. My G. Well, your lordship will see today, if you discontinue 16th June, by 16th June, the list which is already published by you on 17th May. And what are you doing? Well, the entire, if my lordship, what they have done is, they have given them 2 months time. Till 31st of August, time has been given. It appears it has been given to the countries, because it does not specify this. Decided to grant 2 months time till 31st August, to whom time has been given. It appears, logically, if interpreted, it appears this time has been given to the countries, phased out countries, to provide relevant documents. Right. So this is the only objection. So the import which has already happened based on an office memorandum and a published country as a phased out country, then you should not have published it in the first place. But the publication has been.
And I suppose you are also agreeable to comply with that para 8, that writer, page 93 of Gujarat High Court order.
Yes, yes.
That affidavit of undertaking regarding.
Yes.
Ready and willing to pay.
Yes, I am ready and willing to give.
Good. So let me hear Mr. Chatterjee on this.
Fine.
Yes, Mr.
The area of controversy is very little, because the order of Justice BHATTACHARYA is also there, or at page 39. And the Gujarat High Court order is there at page 91. And there's an order of undertaking also. But I shall be praying this, that you would allow the
similar order.
Prayer G.
Prayer G, right.
Prayer G.
With an undertaking by them that they will clear, like Gujarat High Court.
Like and then Lord, give us time, and this order would abide by the final disposal. I was praying for this.
Fair enough, Mr. Chatterjee. Learned Senior Counsel appearing for the petitioner contends that by virtue of the impugned notification dated June 16, impugned office memorandum dated June 16, 2023, the Directorate of Plant Protection, Quarantine and Storage, under the Ministry of Agriculture and Farmers Welfare, Government of India, has reverted back to a notification, a communication dated May 20, 2019, deleting and obliterating the effect of a further office memorandum dated May 17, 2023, on the basis of which the petitioner and several other timber merchants have already acted. Next para. It is contended that by an initial notification dated October 13, 2022, in chapter Roman 2 of plant quarantine within bracket regulation of import into India, bracket close, order, 2003, after the existing entries relating to clause 5 thereof, it was added that in case of consignments requiring pre-shipment fumigation, FUMIGATION, with cap MB small r, originating from countries which have phased out the use of MBR for quarantine and pre-shipment purposes, the consignment shall be released after charging the normal inspection fee. The NPPO of the country would be required to submit relevant documents to NPPO India to establish phased out country status. The NPPO India was to notify the list, which would be updated regularly based on the information received. Next para. Subsequently, on May 17, 2023, an office memorandum was released, along with a list of countries, a list of phased out countries having been published. Full stop. Suriname, শুধু লাস্টে ই হবে, সুরিনেম আর কি বানানটা। Suriname, comma, one of the countries featuring in the said list, comma, has had dealings with the petitioner and imports from the said country are at present lying, comma, having been imported by the petitioner, comma, in the various ports of the country. Full stop. Next para. However, comma, by the subsequent impugned notification, comma, it was indicated that the office memorandum dated May 17, 2023 would be discontinued till August 31, 2023, comma, that is the outer limit given to the relevant countries to furnish all relevant documents to establish their phased out status. Full stop. It is submitted that since the petitioner has already acted upon the May 17, 2023 notification and has invested substantial amounts in terms thereof, comma, the said notification would adversely affect the interests of the petitioner, comma, since the petitioner now would have to pay at least 5 times the amount which the petitioner otherwise would have to pay. Full stop. Next para. Learned Senior Counsel also places reliance on several judgments of learned single judges, comma, of this court as well as the Gujarat High Court, comma, where under similar circumstances, comma, the operation of the impugned notice was stayed. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is seen that the petitioner has made out a strong prima facie case for hearing the writ petition on its merits. Full stop. Accordingly, the respondents are directed to file their affidavit in opposition within 3 weeks, Mr. Chatterjee.
4 weeks.
Within 4 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. Stop. The matter shall be listed in the monthly list of September 2023 for hearing. Full stop. The respondents shall, comma, till disposal of the writ petition, comma, permit the members of the petitioner association stroke timber importers to clear their consignment of timber from plant protection and warranty department, comma, whose consignment from the country of origin is shipped on board prior to office memorandum dated June 16, 2023, issued by respondent number 2, and from the country which are also recognized by respondents as methyl bromide phased out country, vide office memorandum dated May 17, 2023, without any penalty and stroke or any additional fees. Full stop. Next para. However, comma, the above order would be subject to the petitioner filing an undertaking by way of an affidavit within a week from date to the effect that the petitioner shall be ready and willing to pay an additional fees and corona to pay additional fees stroke charges stroke penalty, comma, subject to the final outcome of the writ petition. Full stop. Next para. It is also indicated that the interim order passed herein shall be subject to the outcome of the writ petition as well. Full stop. Next para. In default of filing such affidavit, comma, however, comma, the interim order would automatically stand revoked without further reference to court. আরেকটা লাইন অ্যাড করে দাও। An advance copy of the affidavit, comma, to be filed by the petitioner in terms of the above direction within a week from date, comma, shall also be handed over to the learned advocate on record appearing for the Union of India prior to filing of the same.
The undertaking affidavit to be filed in court.
In court, I have not directed
Wait,
to file to respond to that would create complications.
Wait, please.
আচ্ছা ফাইল্ড যেটা বলেছি না, ফাইল্ড ইন দ্য কনসার্ন ডিপার্টমেন্ট অফ দিস কোর্ট করে। আই এম মেকিং ইট ক্লিয়ার।
তোমাকে forward করে দিচ্ছি।
And you will hand over a copy to Mr. Chatterjee's learner.
Well, this is actually a case for public interest litigation. First time.
True. Let us wait for the Supreme Court to club all the matters.
No, there is one pending because of, there is one pending that usage of methyl bromide and several other chemicals, which is used
Obviously.
for quarantine purposes.
Wait for some time. All these will be clubbed with the Supreme Court matter. Has to be. Yes.
But now these don't go to Supreme Court. This is before the National Green Tribunal.
Oh yes, right. That's the methyl bromide and all.
Upgrade matter item 26.
26 we have
Yes.
the petition. I am for the petition.
With the other side's case, you're ready with the other side's case.
I am my case. I am for the petitioner.
Very well. What is your case? You
Milord,
remember why it was adjourned on the last occasion, Mr. Chatterjee?
affidavit in opposition reply all are filed.
Very well. What is that? I asked you the simple question, what is the defense taken by them? So you're not ready on that. So I'll find it out very well.
Opposite party number to jana.
It's my job, Mr. Chatterjee. I'll have to look into it. Yes, I'll look into it. What is your case? Tell me that.
My case is this my simple point that the OBC certificate in question.
Yes.
I filed an application before the SDO praying for a OBC certificate.
Right.
Without any reason rejected, only the order rejected. Against that order, I prepared an appeal before the district magistrate. The learned additional district magistrate also rejected the same without any reason. Against that order, I prepared this writ petition. This writ petition is filed, my lord.
Where is the order of rejection? Initial order and the next order?
Wait. I think annexure T4. T4.
There was no order, only application rejected.
Page 23.
Page 23 is only application rejected.
Rejected, but without any reason, without it. SDO order বলেছি.
What is the last authority's order, the appellate authority?
Appellate authority district magistrate P7. Page 36. Yeah.
No, an order was passed on 9th of January 2021 by the first authority. Not only this application rejected.
Appellate order 24th November 2021. The undersigned containing the principles of Scheduled Caste and Scheduled Tribe Notification Act and both to be read with the guidelines of the not in a concrete evidence found in favor of the appeal.
They've annexed an inquiry report in their opposition. How do you deal with that?
Opposition inquiry প্রথমেই আছে.
Your subcaste is Shodgop, which falls
Shodgop.
under general category.
No,
So what is your answer to that? Why should the Read Court
as
interfere?
per the judgment of this honorable court, Shodgop is as a Chasa, there is an OBC candidate.
Show me that judgment.
Judgment, my lord, annexed to the Honorable Justice Pratik Prakash Banerjee passed the judgment, my lord. Against that order, they are not prepared any appeal, nothing else.
Page 24.
Page 22, continue.
22 is something else. 24 is Justice Pratik Prakash Banerjee's order.
Yes, lord.
So very well, I'll conclude arguments. This is all. This is all.
This and only
And
seen
reserve judgment, yes.
another point, my lord. In a opposition page and a slip,
That is so Chasa is OPC candidate.
Which page?
19. এইটা একটু দেখিয়ে দিন।
I've got a copy of the opposition. Give me the page number.
Yes.
এটা ফেরত দাও।
পেজ নাম্বারটা বলো না। এটা কিসে? Affidavit in reply. Affidavit in opposition.
You have not paginated your own copy? My copy is paginated. I can understand why Mr. Chattopadhyay, his appeal was rejected. I can understand.
I am unwell and suffering is only for compromise.
You're unwell then also?
No, my lord. Directed word. এইটা দাও ওদের অপোজিশনে।
Give me the second column number, cast code.
9 my lord. এইটা পেজই তো দেখেনি।
Cannot be 9, it has to be 19 then.
Muslim Kotra Muslim Chasa 9 backward classes 82 page the name.
The list starts at page 16. Now calculate and tell me which page is this.
On this
in my copy, your list starts at page 16. This is the second page of the list, or the third page of the list, or the fourth page of the list, or the fifth page of the list. Tell me that only.
এইটা affidavit in opposition. এখানে পেজ নাম্বার কই? 18 এই কলারটা বোধহয়। Notification backward class.
Yes, I found it.
Out.
Thank you. Hearing is concluded. None appears despite previous opportunities, comma, for the respondent authorities. Full stop. Accordingly, judgment is reserved in the matter upon hearing learned counsel for the petitioner. Thank you. I'll pass my orders. I'm going through the documents.
Much less.
Next.
27.
Yes, what is your order?
Sir, sir. My lord, I am for the petition. My lord, I'm a bit handicapped, my lord. I'm led by Mr. Joyantanaran Chatterjee, my lord.
There is a handicap, I'll tell him.
My lord, I am handicapped, my lord.
Yes, if you
He
want
is
to wait for him, but I'll conclude
No,
here.
No,
Yes.
that is, my lord, I have served twice, my lord. Initially, my lord, service was affected on the state, only the state respondents. My
Not
lord,
appearing.
Mr. Siddiqui is, my lord, I have taken
Yes,
information. Mr. Siddiqui is appearing in this matter. My lord, I've tried to serve him. The difficulty is, my lord, he told me that his junior, my lord, he has been, my lord, left out of the panel, my lord, in this matter, my lord. Who was his junior in this matter? That person is left out of
Could
the
you give
panel.
him some more time? What is the grievance in this?
My lord, remission, prayer for remission, my lord.
Remission, the state has
yes,
to
state
be
has to
heard.
appear.
Yes.
After 20
Otherwise, it will be a futile exercise. Today, I'll pass an order.
No.
Tomorrow, another recall application. Your remission will be delayed. None appears for the state at the time of call. Full stop. The learned advocate on record for the petitioner is requested to serve a further notice on the state indicating that the matter shall be listed fairly at the top of the list on August 2, 2023. 2nd August. Yes.
State on Mr. Siddiqui.
Can I direct you to serve on Mr. Siddiqui in
My lord, the
particular?
difficulty is, my lord, when I'll my lord, try to serve on the GP himself, my lord, he will say that there is already an advocate appointed. Well, the difficulty.
আচ্ছা তাহলে যেটা বললাম সার্ভিস on the state না করে on the learned advocate appearing for the state.
Grateful.
Yes.
My lord, may I, my lord, hand over my affidavit of services?
Yes, affidavit of service filed today be kept on record. How many years he is in custody?
22.
Yes.
28.
This is my application, affidavit service to them. Affidavit service to and I am for this one. This is my affidavit of service.
Yes, please. What is the matter?
My lord, the petitioner before your lordship is the one victim of my lord. Defective meter for which an exorbitant bill has come. We made several representation. My lord, kindly come to page 29 once. First. Page 29.
Billing dispute.
Yes.
Not billing dispute. No billing dispute.
So you are agreeable to the bill. If there is no billing dispute, you are agreeable to pay the bill.
My lord, the fact is, issue is in this question, my lord. But in spite of my repeated, my lord, representation, they had not removed the defective meter. And lastly, my lord, they, my lord, disconnected my meter. Thereafter, my lord, they, my lord, send me a notice, my lord, that is page 47 for a meeting. My lord, we are not, my lord, in a position, my lord, to pay the, if any outstanding, whatever their bill, we pray for a simple installment, 10 installments. And there is another grievance, my lord, the wire connecting from the pole to my lord, residence, that is a tile shaded room. My lord, this is in very dangerous condition. That should be, my lord, removed by the, my lord, the licensee. And my lord, the licensee.
For removal of that. Or are you growing wiser after the bill was raised?
No.
What
Before raising a bill, I repeated occasion, I made representations.
for that removal also? For that removal of the pole also?
No. This is subsequent event I have followed. But after filing of this, subsequently this has been occurred.
So whenever you are saying no, Mr. Ghosh, that has to be heard as yes.
My lord.
I asked you two questions. You said no. Both apparently are yes. First of all, you said it's not a billing dispute, but it is squarely a billing dispute. Secondly, I asked you whether the application was made, the representation was made to them for removal of the pole before or after.
No. After, but no. This is subsequently.
The no was the reverse previously. Anyway, so those representations have been given by you.
My lord, page 47 is not
Restored before that billing dispute is resolved.
My lord, may I submit, my lord? My lord, it is stated from the reading of that, my lord, that this meter is seemed to be defective. This is their analysis after my representation.
Did you give the representation regarding the billing dispute, Mr. Ghosh, prior to their disconnection?
Yes.
When? Show me that.
My lord, number of representation, it starts from page 18 and onwards.
Show me the first and the last.
First one is, my lord, page 18.
Yes.
Thereafter, my lord, on 6/9/22. Thereafter, my lord, you can see 19, my lord.
First and last, Mr. Ghosh.
Last is, my lord, 22. In the year 22, that is, my lord, page 19, page 18 and page 19. And thereafter, one of my representation, that is on 1/5/2023.
There are several representations even after that.
My lord.
So how can page 19 be the last representation?
My lord, this annexure has been, my lord, not been edited, my lord, but the date, according to date, lordship has asked me the first and last month, that is this.
And when was it disconnected?
It was disconnected on 6/11/2021.
This is your dispute.
Yes, Mr. And my lord, the last annexure, my lord, can you see page 47 once? After everything, my lord, they asked for this meeting, and till that no meeting was held.
Yes, Mr. Kule.
My lord, page 47, my lord, he has approached the consumers affairs and business fair trade practice. That has got no connection with us. It's a separate independent body. Here this raised the dispute. And in having this, my lord, dispute is pending, my lord will file this writ petition.
No, Mr. Kole, what about their billing disputes having been raised in 2019 and all?
My lord, there is a billing dispute. My lord, actually what has happened, my lord has been paid for installments. In the year 2000, my lord, 17 onwards, we have given installments, he failed.
So they had a grievance regarding the bill meter also. So without resolving that, how could you disconnect? Why should you disconnect? You have to resolve the billing dispute, the meter dispute also, page 18.
Yes. My lord, estimated bill was raised. As per your lordship knows, my lord, this since sometimes, my lord, meter was short, and that's why without meter reading,
the meter was changed.
Average bill was raised.
Was the meter changed?
No, not yet, my lord, because in the meantime it was disconnected.
No, if it is not
21.
changed, no. 21 it was disconnected. They first alleged the meter being defective on January 2019.
Yes.
For 2 years you did not change the meter. You are raising estimate.
No, average bill. On the
Cannot
basis of
be,
his
cannot be.
previous, as per regulation, your
No.
lordship knows me.
As per the regulation, you have to immediately replace also. You have to have an inspection within 30 or some days.
Yes, that is there. My
If
lord.
that is not there, you cannot raise these average bills. Go on and
No, my lord, he was consuming electricity.
consuming.
That's why, my lord,
Our
average-
defective meter. He had raised the allegation.
Yes, my lord, that can be resolved by the RGRO. I have no objection.
Then you have to reconnect and then resolve, Mr. Kul.
As your lordship, but my lord, as of date, my lord, there is an outstanding dues, my lord, 10,000 and odd, plus LPSC 6,000 and odd. As your lordship, my lord.
16,000. What is your occupation?
My lord, daily labor.
So these dues is from 2018 onwards, not my lord, once.
Daily labor. Your occupation is business.
Business, my lord.
Business of daily labor.
Oh, sorry, my lord. This is LIC agent, my lord. I'm correct from my junior, my lord. LIC agent.
Well, let him deposit the
Pay
amount.
16,000.
We have restored.
16,000 by installment, my lord. I am not by installment, my lord. This is because
16,000. No. You earn from one customer more than that.
no. LIC has now, my lord. LIC is.
Mr. Ghosh, do you know this? LIC agents don't want to be promoted further.
My lord, this is a commission basis agent, my lord. This is not the, my lord, the permanent staff, my lord. This is the
Apart
commission
from your
basis.
client, everybody knows that. No, Mr. Ghosh. You have to
My lord,
pay
this
the
is
amount
my
that will be
senior
subject.
My lord, kindly give some installment, my lord.
I am not asking you for your concession. I'll direct you to pay 16,000, but this will be subject to your resolution. I'll direct them to resolve the issue upon hearing you within, say, 3 weeks.
Yes.
My lord, and my lord, meter will be replaced, my lord. After I pay, immediately after payment, no reconnection charge.
First inspected.
My lord.
Then if necessary, replace.
Yes.
My lord, inspection done, my lord. They also, my lord. That is why I'm page 29, my lord, seems defective. Meter seems defective.
Oh,
My lord, page 29.
Show that.
Inspection done. Even after they did not change.
No, that was
Yes.
not inspection.
Kindly see page 29.
Meter
During meter reading, it seems defective.
Meter reader says seems.
Seems defective in the from bottom 5th line.
As your lordship, my lord, we will replace the meter if it is.
Even after my lord, detecting that problem, they are not changing.
No, sometimes.
No, Mr. Kola, then even 16,000, why should he pay?
No, that is the consumption, my lord.
Current
was-
bills
that
he will
was
be
not-
paying, that will be subject to, I'll keep the writ petition.
That is, my lord, consumption. That is admitted. My largest pen is all along paying for installments. We have given installments once, twice, thrice. He failed to pay the installments, and lastly, my lord, we have disconnected. And not a case that we have not given chance. We have given so many installments.
Mr. Kola.
Your lordships kindly consider, my lord, my largest pen, it's an admitted position. This use is admitted. But
Used on
other,
the basis of the defective meter which you did not replace despite having observed.
my
in
lord,
20
yes, my lord, that
No.
can be, my lord, that is the, my lord, on average basis as per regulation, but my lord, subject to the RGRO's order, my lord. It can be, my lord, after finalization, if my land expense pays, my lord, that can be adjusted always.
This is not a mere RGRO case, Mr. You did not replace the meter. Where is the question of the on what basis will the RGRO decide?
No, my lord, average.
The meter was defective. Why should average bills be taken at all?
My lord, consumption.
After you know that it's defective.
No, my lord, my land nuisance client is consume electricity. In spite of having defective meter, my lord, connection was there. He was consume electricity.
Learned counsel
That is,
for
my lord.
Learned counsel for the petitioner argues that despite having pointed out to the WBACDCL as long back as on January 4, 2019, and several times thereafter, as regards the electricity meter used by the petitioner being defective, and despite the WBACDCL itself having expressed the same apprehension, the said meter was never replaced. First up, the WBACDCL went on charging exorbitant amounts on the basis of the defective meter, and ultimately the petitioner's electricity supply was disconnected for non-payment. First up, next para, the petitioner has also approached for resolution of the dispute, the next date of which was fixed on November 28, 2022, but nothing has yet happened with regard to such resolution. First up, next para, learned counsel for the WBACDCL submits that there was no inspection but merely an observation that the meter seems to be defective, in a particular bill raised by the WBACDCL Full stop. That apart, comma, the petitioner, comma, it is submitted, comma, has regularly been consuming electricity, comma, for which he is liable to pay electricity charges. Full stop. Next para, insofar as the resolution is concerned, comma, the petitioner never approached the grievance redressal officer. Full stop. The document annexed at page 47 of the writ petition is a communication made by the Assistant Director of the Consumer Affairs and Fair Business Practices, comma, which is a distinct and different authority from the WBACDCL and was approached by the petitioner. Full stop. Next para. Upon hearing learned counsel for the parties, comma, what is evident is that the petitioner raised an issue of the meter being defective as long back as on January 4, 2019 and several times thereafter. Full stop. In a particular invoice, comma, in a particular bill, comma, dated November 16, 2019, comma, annexed at page 29 of the writ petition, comma, the WBACDCL itself indicated in a note at the bottom of the bill that the meter in question seemed defective and the reading was on estimated basis. For sub next para, it is unfortunate that in spite of detecting such defect as long back as on November 16, 2019, comma, the said meter has not been replaced by the WBACDCL till date, comma, for reasons unknown. Full stop. Next para. Hence, comma, the WBACDCL cannot avoid liability for the defective meter, comma, merely by going on raising average bills on the basis of estimated charges, comma, despite having not done its duty in replacing the defective meter within the stipulated period under the regulations. Full stop. Next para. Taking into account the fact that the petitioner did not approach the grievance redressal officer for resolution regarding the bills, comma, in conjunction with the inaction of the WBACDCL for not replacing the meter, comma, WPA 13003 of 2023 is disposed of by directing the WBSEDCL to replace the defective meter of the petitioner immediately, comma, positively within 1 week from date. Full stop. Next para. The petitioner, comma, thereafter, comma, shall go on paying current charges for the electricity consumed by the petitioner. Full stop. However, comma, the electricity connection of the petitioner shall be restored also within a week from date, comma, without insisting upon prior payment of the amount of arrears which has been claimed by the WBACDCL for the relevant period. Full stop. Next para. The petitioner shall refer the dispute raised in the present writ petition, comma, regarding the billing of the WBACDCL for the relevant period regarding which arrears have been raised, comma, when the meter was defective, comma, by July 31, 2023. By Monday, you will make that application. By July 31, 2023, before the appropriate grievance redressal officer, full stop. If as and when such an application is made, comma, the grievance redressal officer shall decide the said dispute in accordance with law upon giving opportunity of hearing both to the petitioner as well as the distribution licensee as expeditiously as possible, comma, preferably within 4 weeks from the date of such reference being made. Full stop. Next para. It is made clear, comma, however, comma, that the arrears payable by the petitioner shall revive upon being decided by the grievance redressal officer full stop, in the event the petitioner does not pay such arrears, comma, even upon being adjudicated by the grievance redressal officer and or a further appellate forum, comma, if so approached by either of the parties, comma, it will be open to the WBACDCL to disconnect the electricity in due course of law, comma, for non-payment of such adjudicated arrears. Full stop. It is further clarified that nothing in this order shall prevent the WBACDCL from taking appropriate steps for disconnection in due course of law, comma, in the event the petitioner defaults in making the current payment of electricity charges. Usab, this court has not entered into the merits of the allegations regarding the bills raised by the petitioner, and it will be open to be decided on all issues by the grievance redressal officer. No address to cost. Urgency.
তুমি ক্লারিফাই করো মিটার কস্ট মিটার কস্ট কিছু
29.
Reconnection upon reconnection charges at least. Otherwise, we'll have the statutory violation.
আচ্ছা very good. একটা জায়গায় বলছি directing the WBACDCL to restore the electricity supply of the petitioner বলি upon payment of only the reconnection charges.
Grateful.
Thanks.
This 29.
Yes.
My lord, in terms of 25 July order, I have received the minutes, my lord. My lord, upon perusal of the receipt, my lord, minutes, my lord, I have found two judgments. One was authored by your lordship in Gopal Sarkar case, my lord. After the copies. And one judgment, my lord, passed by the coordinate bench of this honorable court. My lord, in your lordship's order, my lord, at para 36, your lordship has been pleased to observe that the composition has to be there, has to be a member district judge in the SSRB. And in that view of the matter, my lord, your lordship has been pleased to set aside the minutes, my lord. My lord, in the impugned minutes, my lord, which I have received from my learned friend, my lord, the chairman was additional chief secretary home. There was no district judge was taking participation in the proceeding, my
Which
lord.
page should I look into from the report? Yes.
From the minutes. From the minutes, my lord, I handed over to the court by my learned friend. 80 didn't.
Eta?
Extra copies, sir.
No, no, but I'll just. Eta bodo.
Extra copies.
The statement of facts.
My lord, this one. Mr. BP Gopalika, Additional Chief Secretary, Secretary in Charge, Principal Secretary, ADG and IG, Inspector General of Police, Joint Commissioner of Police, Chief Prohibition.
Is not there, DM.
District Judge, my lord.
District
Judge. My lord, in the coordinate bench judgment, my lord, your lordship judgment of Gopal Sarkar has been taken into account, and the honorable coordinate bench has also allowed the similar circumstance case in 302 matters, my lord. When the accused is in custody for murder, 302, my lord, and he's in custody above 14 years. My lord, the date of sentencing of my client, my lord, is 18 September 2006, my lord. My lord, one more issue I may kindly drag your lordship's kind attention is section 432 clause 2, my lord. My lord, there was no reference also sought for. In the coordinate bench judgment, my lord, his lordship, Vivek Chaudhary lordship has been pleased to observe at paragraph
Paragraph 6, my lord, in SCC. 432 clause 2 of the Code of Criminal Procedure provides that whenever an application is made to appropriate government for suspension or remission of a sentence, the appropriate government may require the presiding judge of the court before or by which the conviction was held or confirmed to state his opinion as to whether the application should be granted or refused, together with his reason for such opinion, and also to forward with a statement of such opinion a certified copy of the record of the trial or of such record thereof as exists. Thus, a judicial scrutiny is contemplated in the provision contained in section 432 clause 2 of the code, and sufficient reason are required to be provided so that appropriate government may not take any arbitrary decision with regard to suspension or remission.
Mr. Sinha, you could not find there are several other judgments which even of the Supreme Court which say that these criteria have to be, these yardsticks have to be looked into.
My lord, one judgment I have annexed in the writ petition, my lord.
Where is that?
My lord, it was authored by Honorable Chief Justice of India, page number 20.
Followed by several benches of this court.
My lord.
Show me that the Supreme Court judgment, yes.
My lord, it starts from page number 25.
It is mostly about the current conduct, the recent conduct of the
Recent conduct and
convict, yes.
recent conduct and how he behaves in the outside.
Parole, yes. Parole conduct, conduct in jail, all these things have to be seen.
Taken into
What are
account.
his chances of recreating the same circumstances or crime?
My lord.
Where is that? In
My lord.
In the Chief Justice's order?
My lord. My lord, it starts from page number 28, my lord. Paragraph 8. Imposition of the requirement that a convict undergoing imprisonment for life would not be eligible for premature release until attaining the age of 60 years. My lord, my client falls as is 64 years. Led to institution of petition under Article 32 of the Constitution before this court. The challenge was inter alia on the ground that the plea for premature release must be considered on the basis of law as it stood on the date of conviction, and that a subsequent policy which operates to restrict the ambit of the policy prevailing on the date of conviction must not be allowed to obstruct the plea of the release. Moreover, it was urged that the requirement that a convict cannot be considered for premature release before the age of 60 would violate the right of life under Article 21 by subjecting a convict to long years of incarceration. In several judgments of this court, including State of Haryana versus Jagdish, it has been held that an application for premature release has to be considered on the basis of policy as is stood on the date when accused was convicted of the offense of the trial court. A similar view was taken in the State of Haryana versus Rajkumar alias Bittu. Subsequently, on 27 May 2022, policy dated 1st August 2018, as amended on 28 July 2021, was further amended. The amendment are specific to para 1(2)(b), paragraph 2(f), 2(g), and by insertion of para 12 of the policy dated 1st August 2018. As amended. For the present purpose, it would be suffice to note that the requirement that convict undergoing life imprisonment could be considered for release only after attaining the age of 60 has been deleted. The amended clause in the terms in the amendment dated 27 May 2022 read as follows. All such male convicted prisoners sentenced to imprisonment for life and are incarcerated in prison whose crime is not covered by any of the sub-rule under prohibited category defined in para 3 below, and who have undergone, including under trial custody, sentence of 16 years, my lord, excluding remission, and 20 years including remission. Moreover, as regard to prisoner who fall in the prohibited category contained in para 3(6) of the relevant clause, read as follows. All such convicted prisoner sentenced to imprisonment for life are incarcerated in prison whose crime is covered by section mentioned in prohibited category in sub-rule 6, 8, and 9 of the para 3 below, and who have undergone, including under trial custody, sentence of 25 years with excluding remission and 30 years including remission. Following the amendment, counter affidavit were filed before this court in several pending matters. My lord, these are the details of the matter. My lord, thereafter, I may drag your lordship's kind attention at page number 36. My lord, these are the list of convicted criminals who have been released, my lord, who have been considered.
Yes, so let me hear them. Yes.
My lord.
Yes.
Now, my lord,
Mr.
so far,
You have not followed your own guidelines of the National Human Rights Commission, which you have annexed also,
Lordship.
fairly enough. So because the current behavioral pattern in
My lord.
jail during
So far,
the
so far this
incarceration.
order is concerned, that is of 2021. So, my lord, if Lordship so directs, my lord, accordingly, my lord, we will constitute and, my lord, if he made, then he has to make a fresh application because that his prior application has already been rejected. My lord, if, my lord, then in accordance with, my lord, the guidelines framed, my lord, we will, my lord, acted upon, my lord. Man, Lordship, dekheche to roof has been recorded.
Yes.
No, it has been recorded that it has been rejected, my lord. Thereafter, my lord.
It has been rejected.
Lordship, Lordship.
Act order record করুন। The grievance of the petitioner, who is already you're in behind bars for 16 years.
23 years, my lord.
Who is in incarceration for about 23 years, is that the petitioner's prayer for remission was refused by the respondent authorities. Full stop. Next para, learned counsel places reliance on several judgments of this court as well as the Supreme Court to indicate that the relevant criteria were not considered by the respondent authorities while making such rejection. Full stop. Next para, it is further submitted that the concerned district judge was not a part of the state sentence review board, which considered and rejected the petitioner's application for remission. Full stop. Next para, learned counsel appearing for the respondent authorities submits that the last rejection took place in the year 2021. Full stop. Hence, in the event the petitioner seeks remission, in view of the previous rejection, he has to make a fresh application, which can be considered by the respondent authorities in due course of law.
No, I'm extremely sorry, my lord. It is 5/4/2022, not 21, my lord.
আচ্ছা 2021 টা 2022 করুন। যা বললাম next para, a perusal of the impugned order of rejection, as disclosed by the state as well, indicates that the consideration before the state sentence review board in its 67th meeting held on April 5, 2022, which also comprised of the rejection of the present petitioner's application for remission, was on an extremely cryptic note. Full stop. Next para, the remarks against the present petitioner's application for remission, in the remarks column read that the petitioner cold-bloodedly murdered his wife and 5 daughters, inhuman in nature, chances of future recurrence cannot be ruled out, there is no one to look after him in family, local people raised strong objection, considering nature of the crime and objection by local people, premature release proposal was strongly opposed. Full stop. Considering the objection by police authorities and apprehension about rehabilitation, premature release was not recommended by the board. Full stop. The state merely acted upon such recommendation and refused the petitioner's application. Full stop. Next para. However, the guidelines relating to premature release of convicts / prisoners, as formulated by the National Human Rights Commission, which has been fairly handed up by the respondent authorities themselves, indicate that there are several other considerations which were omitted in the impugned recommendation of the state sentence review board. Full stop. Next para. In a communication dated February 11, 1999, the Joint Secretary of the National Human Rights Commission circulated among all the IG within bracket prisons, bracket close, stroke, chief secretaries of states, comma, etc., the relevant guidelines. Full stop. Clause 5 of the said guidelines pertain to procedure for processing of the cases for consideration of the review board. Full stop. In clause 5.2, comma, it is stipulated that the superintendent of jail shall prepare a comprehensive note giving out the family and societal background of the prisoner and, comma, inter alia, comma, will reflect fully about the conduct and behavior of the prisoner in jail during the period of his incarceration, comma, behavior stroke conduct during the period he was released on probation leave, comma, change in his behavioral pattern and the jail offenses, comma, if any, comma, committed by him and punishment awarded to him for such offense. Full stop. A report is also to be prepared about the physical stroke mental health or any serious ailment with which the prisoner is suffering, comma, entitling his case special consideration for premature release. Full stop. Next para. Clause 5.3, comma, again, comma, stipulates that the superintendent of jail shall also make reference to the superintendent of police of the district where the prisoner was ordinarily residing at the time of the commission of the offense, comma, for which he was convicted and sentenced, comma, or where he is likely to resettle after his release from jail. Full stop. Next para. There is a detailed modality spelled out in the said guidelines. Full stop. Next para. Although a presumption may very well be raised in the present case that the said modalities were substantially complied with by the state, comma, even proceeding on such premise, comma, it is seen that the consideration by the sentence review committee did not take into account the relevant criteria and yardsticks stipulated by the guidelines of the Human Rights Commission. Full stop. Tests such as the conduct and behavior of the prisoner in jail during the period of incarceration, comma, his behavior stroke conduct during the period he was released on probation leave, comma, change in his behavioral pattern during his incarceration, comma, the potency of the petitioner in committing the crime again, comma, as well as to create conditions which might be detrimental to the people of his neighborhood, comma, have not been considered in detail in the said review committee meeting. Full stop. Next para. That apart, comma, the composition of the committee is committee jagata board korada, sorry. The composition of the board is also adheres the provisions of the guidelines, comma, since the concerned district judge was not a component of the said board. Full stop. Next para. Keeping in view such criteria, comma, the matter is required to be remanded back to the state sentence review board for a further consideration. Full stop. Next para. Since the petitioner had already made an application, comma, which was improperly considered by the state review committee, sentence review board, comma, a further application of the petitioner is not required. Full stop. Next para. Accordingly, WPA 14257 of 2023 is disposed of by directing the respondent authorities to place the matter afresh before the state sentence review board, comma, constituted properly in accordance with law and relevant guidelines, comma, for a reconsideration of the petitioner's application for remission, comma, upon taking into account all the relevant yardsticks as stipulated in law and settled by several judgments of the Supreme Court and this court, comma, also considering the ingredients as spelled out above in the present order. Full stop. It is expected that such reconsideration shall be held as expeditiously as possible, comma, preferably within 3 months, preferably within 3 months from this date, full stop. The state respondent shall constitute a proper state sentence review board for such purpose, comma, if necessary, also placing before the said board other pending remission applications of other prisoners, comma, as expeditiously as possible, comma, positively within 1 month from this date. No address to cause urgency.
Grateful.
Grateful.
দুটোর সময় আমি বসবো, এটা যদি হয়তো হবে। আচ্ছা, দুটোর সময় এটা নেবো, তারপরে সোয়া দুটো পর্যন্ত বসে থাকবে। থ্যাংকস।
Grateful.
original site supplementary list.
I'm passing that modification. Upon hearing learned counsel for the parties, the order dated July 27, 2023 is modified to the effect that the order of injunction passed therein shall be restricted only to the sale of the NPAs belonging to the writ petitioner. Full stop. It is further clarified that with regard to the other loan accounts, which do not belong to the petitioner, but are covered by the impugned proposal of sale annexed at page 50 of the writ petition, the respondent bank shall be at liberty to proceed with the sale proceed with the proposed sale. Full stop. Let this be let this order be deemed to be a part of the order dated July 27, 2023. Full stop. All parties, all concerned shall act on the communication of the learned advocates for the petition.
So,
Thank you.
just getting old, should have pointed this out.
No, no,
yesterday.
no. It was a lengthy hearing also for, for an ad interim order, that was quite a lengthy hearing on both of your part. Yes.
You go to your lordship's to sit till 5:30 to hear it.
No.
Because this is the principle. I find it is easy to do matters, but to get the matter done when it is important, when it is when the iron is hot, so to speak.
That's true.
Grateful, my lord.
I think your lordship appreciates all this because of your.
No, has to.
Yes. Otherwise, your lordship
Yes,
has
yes,
faced these problems much more than we have.
Too young as a judge to forget me, sir. And I'll ever be.
So grateful, my lord.
Grateful. ভালো করে আমি হারিয়ে দিয়ে বলছি grateful.
Appellate side.
স্যার grateful তো বলো স্যার কি বলো তো জোরে হারিয়ে তারপর বলছি grateful.
Appellate side, new motion, item number 30.
I am for the petitioner.
Yes, Mr. Shah, what is the matter?
I am for the petitioner.
Obviously, yes.
I purchased property on 11th October 2021 from. I purchased property from respondent number 4 by deed number 11th October 2021. And at page number 36, my description of the property is given.
Yes.
I have purchased the ground floor. This is a two-story building. I have purchased the ground floor.
Yes.
And the respondent number 4, I have purchased from the respondent number 4. And it is alleged that respondent number 4 also sold out the first floor to the respondent number 5. Respondent number 5. There is a existing place for a meter room in front of the room, in front of the room gate, and the respondent number 5 have separated a meter room. Now the fact remains, I have applied before the CSC for new electric connection, running page 79 on 19/7/2020. 22.
Yes.
But electric supply in collusion with the respondent number 4 and 5 are not installing meter.
What about service on the private respondents? You have served properly?
I have
Affidavit service.
it is.
Proper service has been effected
Yes.
on all?
Yes.
You have checked up? Yes, Mr. Guchait, what is your case?
My lord, they applied on 18/6/2022. Thereafter thrice, my lord, we made an attempt to give, my lord, to install the meter in the, my lord, set, my lord, common meter position.
Yes.
Lastly, and also from all the occasions, we have been obstructed by my lord the respondent number 5, the my lord respondent number 5 is the main person, my lord, who is obstructing us.
Despite service, none appears for the private respondent, although the petitioner and this distribution licensee are represented through counsel. Affidavit of service filed today be kept on record. Full stop. The petitioner has purchased the ground floor of the property in question on June 18, 2022 from the respondent number 4. Full stop. The respondent number 4, apparently, has also sold the first floor of the same building to the respondent number 5. Full stop. However, when the petitioner sought to get a new electricity connection in the petitioner's name, the respondent number 5 has been objecting to the same. Full stop. Next para, learned counsel appearing for the CSC Limited also submits that the CSC Limited has attempted thrice to give such connection to the petitioners, but could not do so due to obstruction raised by the private respondents. Full stop. Since the petitioners have a right to get electricity connection at the premises, being in occupation of the ground floor thereof, WPA 116835 of 2023 is disposed of by directing the CSC Limited to give an electricity connection to the petitioners at the premises in question, as expeditiously as possible, positively within 1 week from date. Full stop. In the event any obstruction is 1 week from date, subject to compliance of all formalities by the petitioner. In the event any obstruction is raised by the respondent numbers 4 and 5 and or their men and agents, the CSC personnel will be at liberty to approach respondent number 3, the officer in charge of the Kalitala Ashuti police station, who will grant police assistance to the CSC personnel if so approached, at the cost of the petitioner. Full stop. If the CSC personnel, if any padlock or other hindrance is put up by the respondent numbers 4 and 5 to prevent the CSC personnel from having access to the existing meter board position, it will be open to the police personnel to remove the same for the limited purpose of giving access to the CSC personnel to comply with this order. All parties shall act on a server copy of this order without insisting upon prior production of certified copy. No arrest to cause urgency.
Yes, my lord. Your lordship is rightly, my lord, said, my lord. The already, my lord, the refund is being locked by the said, my lord, private respondent 5.
That is an usual order.
That is an usual order. Yes. Get to your lordship.
31.
31, Lordship, I am led by Mr. Ponchanan Hajra, appearing behalf of petitioner. He is ill, Lordship. So I am praying for 2 weeks.
An adjournment is sought on the ground of petitioner. Let the matter stand adjourned till when? Till when?
10 or 11 August.
Adjourned till August 11, 2023.
I'm appearing for the bank, my lord. Respondent.
They are not enjoying any interim order.
My lord, yes. There is no interim
order. No interim. This is for the first time.
A very simple case that one of the heirs of the deceased account holder is not giving consent so that we can disburse the amount to all the 4 heirs. This is
could have been resolved today.
It could have been resolved today.
He's ill.
32.
Lord, I am for the petitioner. Affidavit of service.
But I am appealing for the state.
Right.
Lord, in this matter, I have challenged.
Can you please take the microphone a bit closer to you?
Yes. Lord, I have challenged the order of refusal of permission to use methanol in the manufacture of thinner and other chemicals. Lord, the fact is that, my lord, facts of the case in brief is that, my lord, the appellant is the manufacturer of thinner and varnish and black chapan, etc. And while manufacturing this, they are using denatured spirit and special denatured spirit and ordinary denatured spirit. And my lord, they came to learn that if the methanol can be used, better quality of thinner can be used, can be manufactured, and which will be less costlier, and which has a good market, And if that can be materialized, then the factory can be expanded and more generation of employment also will be possible. He made a representation before the my lord, excise commissioner. It is at page 26.
The permission is required under which law?
Permission is required, my lord, because my lord, earlier, my lord, when I was started commencing the business of manufacturing of thinner, permission was granted for using hazardous item of ethyl alcohol and ethyl alcohol.
What is your present grievance? They are not deciding on this, or they have rejected?
Rejected. They have rejected. So, my lord, I have made a representation which is at page 25, 26, my lord. And my lord, in this representation, I have stated that I want to use methanol, and that methanol is of there is great demand of thinner manufactured from methanol because it yield a good product and it also cheaper.
Yes.
And then, my lord, this representation was not replied to, and thereafter, my lord, various reminders were also given, and nothing was transpired. Ultimately, my lord, they had kindly come to page 32. The authority from the office of the additional district magistrate, collector of excise directed me to submit some documents. I have submitted those documents. Which is page 33. This is my letter by which I have submitted those documents. Now, my lord, then next, my lord, kindly come to 34. This is the important letter, my lord. By this letter, he has initially rejected my prayer of using methanol for storage and using of methanol. My lord, kindly peruse this letter, my lord. This is the letter by which I refused. With reference to the above mentioned subject, I am directed to inform you that the application for grant of license to possess and storage of methanol for manufacture of thinner and lacquer has been considered and rejected on the ground that, as per the order of the Excise Commissioner, West Bengal, methanol should not be allowed to be used for production of any substance wherein methanol is not essentially required and may be substituted by other materials. Moreover, from the report of DEC, HON'BLE range, that is the inquiring officer, it transpires that applicant is not well equipped to handle the methanol like hazardous substances and they do not have any explosive safety license. This is the reasons I have given. This is based on one order. Kindly see page 36.
Yes.
Kindly see this is the order. By this order, they have said
if any option is possible, then methanol should not be used.
Yes, this is the order.
Yes.
I have challenged this order, but because I contested that such type of order is not in existence. Because
not in
existence. Because
you said there is no order at all.
There is no order at all. Achha. Because this is in the name of order, my lord. This does not contain any signature. This does not contain any reference number. No date. Everything is there. I contested this. My lord, kindly come to page. Give a detailed reply, my lord. Kindly come to page 47.
Yes.
Kindly refer to your memo number 27, 2022 on the above conveying rejection of your application, our application. Now, while rejecting our application, praying for permission to possess and storage of the methanol for the manufacture of thinner, reliance has been placed on an order of Excise Commissioner. It will be pertinent to mention that the said order of Excise Commissioner, which has been annexed to your memo, does not contain any order number, nor any signature, nor any date. The said document cannot be said to be valid order for deciding my application. This first contention I have taken. Second, my lord, further in our application, we have stated that we have wanted methanol for the manufacture of good quality of thinner and reducer, etc., to cater the demand in the market and sale of such material of finished goods. Also would be increase the huge amount of government revenue. For the reason methanol is essentially required. There are a number of industries using methanol. We cannot be deprived of granting permission for use and storage of methanol for the manufacture of thinner and other things high quality and higher quality. Further, reference of the report of DEC HON'BLE, which has been made. A copy of the report of DEC has not been provided to us. We are not in a position to know what is the report has been submitted by DEC HON'BLE range. We make it clear that we are well equipped to handle methanol. For this purpose, we also make it clear that explosive safety license is not required. exclusive shift license is required to those industries which are having fire license, and hence exclusive shift license is not required, and absence of which cannot be a ground for and denying the rejection of our application. We humbly submit that we are well equipped to infrastructure to handle the methanol. We want to use methanol for the purpose already mentioned above. We are paying GST such and such. My lord, in this connection, I am showing, my lord, one gazette notification at page number 39. It was issued by the department, Government of West Bengal, my lord, 39. In this notification, the list of hazardous items have been given. My lord, kindly see page number 40. 40. List of hazardous substances.
Methanol is not there.
Methanol is not there.
Mr. Bera will continue tomorrow. I have a division bench. So we'll come back, not tomorrow, Monday, please. Although the matter is taken up for hearing, the same cannot be concluded today due to paucity of time. Let the matter stand adjourned for further hearing till Monday. That is July 31, 2023. এটা একটু উপর দিকে দিয়ে দিও, মোশনের পরে উপর দিকে দিয়ে দিও। Fix it.